Hello.
And what's been equally hard is not only having to answer the questions from my daughter, who was 7 at the time, my baby girl, who was 7 at the time, is now 8. Attempting to answer her questions that she's asking, and still continue to shield her from what she sees, what she hears.
Hey guys, sorry.
Having a newborn son
I'm trying. I'm here.
that I haven't even been able to meet.
I don't know what I missed so far, but I'm sure it's been a shit.
I haven't been able to hold, touch, kiss.
It's been absolute dog shit.
Having to navigate everything that comes with this whole situation. While still attempting to wrap my head around it. I can't honestly say how many times I've sat in my cell, especially during lights out, alone, where it's just you. And just been praying and asking myself, how could this happen? Not just for the people.
Yeah. Danny asks, how could this happen? I mean, you of all people would know why this happened.
How the hardest questions you can ask is those that don't have an answer. No matter how much thinking you do, no matter how much you try to look at it from different perspectives and listen to other outside perspectives and listen to people that you trust and that you love, still coming up with nothing. But to think for 1 second, one question I never had to ask was if this was intentional. That's something that I never asked once.
So basically, is
I
he?
know it wasn't.
How do you know it wasn't intentional? So I mean, he's ultimately conceding that he was behind the wheel and was the driver. I mean, throughout this entire thing so far, he's conceding that.
My mind to even attempt to ask myself that.
So the whole song and dance of trying to make an argument that of a misidentification is basically null and void at this point.
And I know sometimes during this trial probably doesn't show. Maybe hard to believe. But trust me when I say no one outside of the families that had to go through this, no one's heart is more in pieces than mine.
You sure as shit haven't shown it. Because this entire sovereign citizen bullshit is an attempt to absolve yourself of all responsibility.
So again, I go back to all these exhibits. Go back to everything that's been shown, everything that's been testified to. Everything you've heard during this whole process, this trial. And again, I say the same thing that I said earlier. Same thing I said in opening statements. I'm not reading from any paper, any books. Everything you've heard in opening statements, everything you're hearing now is from right here. Everything.
I practice legal law, pure chaos.
You have the decision. You and you alone. All of you. You have the decision. I'm sure you've taken a lot of notes during this process. Some days are longer than others. A lot of movement in and out of the courtroom for various reasons. Remember the power that you have.
So I did hear, I was listening in on my way home.
Taken away from you.
And that he tried to raise jury nullification. The judge tried to sweep it down, but the prosecutor asked for a compromise to let him go off.
I can never understand the position of sitting on the jury in something of this magnitude. So I'm sure there's a lot of pressure. I pray that the right decision is made. The right decision.
There's no doubt in my mind the right decision is going to be made.
It's almost like that message, well, not message, but that writing when we're in our vehicles and we got that rearview mirror and it said things are closer than they appear. But it's also another way of saying sometimes things aren't as they appear.
Oh my God.
I can't speak for anyone else, but me, myself, I believe in Jesus Christ.
Oh, you a dick.
That's how I was raised. That's what I believe in.
Is that in between instances where you beat your girlfriend, the mother of your child?
None of us are perfect. But I try every day to make sure that I acknowledge him. That's why every time I step in this courtroom, I have my Bible with me everywhere I go.
The Bible with you, that's property of the Waukesha County Jail.
This is not something that started at the beginning of this incident. This is something that has been instilled in me since I came out of the womb. This is how my family lives their life. This is how we was raised.
Hey, Vintage. Hope you're doing okay.
For whatever mistakes that I myself have made in my life, I've made peace with God. Made peace. I'm happy to say that my conscience is clear.
Really?
And because I believe, I trust him with my life. Nobody will never know why it was his will for this to happen.
So you're absolving yourself of any kind of agency here.
That day, mine included.
None of your actions are what led up to this.
And no matter how much sometimes we want to question, we have to have faith.
This is such a bunch of bullshit. Any of these tears are only for himself.
Look inside yourself.
Even assuming, and that's a big assumption that they're genuine.
Look inside yourself and make the right decision.
Oh my God. Guilty as fuck.
Look inside your heart. You have everything in your hands now. Everything.
I know, Archer, I'm sorry. I need to feed them. But I wanted to
Do what's right.
see the rest of this shit show.
was right.
Okay. Again, I note that he abscond or he
Let the smoke and mirrors take away your power. Don't let the theatrics take away your power.
He's got a lot. Okay, I was about to say this because he brought it up earlier. He's got a lot of fucking chutzpah to talk about the prosecution's theatrics with this fucking show.
Each and every one of you has a decision. Who was right? Make the right decision.
I have full confidence the jury will make the right decision and find you guilty of all charges.
It's hard to think about my younger kids getting older and at some point having to explain everything to them. Kids don't stay kids forever. And nowadays, kids is frankly a lot smarter than we were when we was kids.
Oh my god. Okay. I'll be right back. I'm gonna go feed Archer real quick. Oh my god.
I got a letter the other day. My youngest daughter. And she's still learning cursive right now, so she's the best writer when it comes to cursive. She'd rather print. She said, "Dad," and this is from the letter. She said, "Dad, why are people saying all these mean things about you?" I haven't read the rest of that letter yet. The rest of that sentence said,
All right, I fed him.
I know.
Oh, thank God, that's right. The prosecution has a rebuttal opportunity. Thank God.
Throughout this year, I've been called a lot of things.
Oh my God, woe is me. I'm being called names.
And to be fair, I am a lot of things.
Murderer?
A murderer is not one of them.
Misogynist?
Never has been, never will be.
Narcissist? Unrepentant asshole?
Before I close my statements, just want to say, open your hearts.
Thank you, for the $2, Mrs. Shucklers. Thank you, Thomas, for being a 18-month member.
Go inside yourself when making this decision. Have no fear. Pray and do what you know is right.
He's given an hour. I don't know how long this has gone on.
What you know is right. Think about everything you've heard. Think about everything you haven't been privy
About
to.
about 45 minutes so far I've gone on.
Think about the whole entire picture. And above everything, whatever you decide, make sure you yourself can live with it.
I don't think that's going to be difficult for the jury. You're guilty
That's
as...
the magnitude of the power that you have. Just like this tissue is in my hand, this is everything. You have everything.
What? Fake tears?
Do what you decide.
The jury has fake tears.
Had no regrets. Don't let this decision weigh on you after it's over. Hopefully we got a lot of living ahead of us.
They do. You don't.
We're willing. Don't look back and kick yourself in the behind. It's been about 3 weeks with you. And it took a lot of courage and a lot of guts to pause your life for this. To put important things on hold. To to basically stop your life. You should be commended for being able to sit up here with this amount of pressure.
The jury was able to voluntarily stop their life.
Not lost on me. I'm sure it's a lot. And you all should be commended because it took courage to do this.
6 people that he killed didn't. They didn't have a choice.
But I would bet a lot of people wouldn't want to be sitting in your position right now.
You made that choice to stop their lives.
And you guys had the guts to do it. Thank you for that. Thank you for taking pretty much a month and setting it to the side for this. I know it's probably not proper, but you guys deserve a round of applause if you could get one.
Oh, eat a dick.
Thank you guys sincerely. And I know, and I have faith and I trust that you guys know what's right. Ladies and gentlemen, I don't think it's fair to just say guys, but
Fucking hell.
I believe in your heart you know what's right. Thank you.
Thank you, sir. Before I give the state an opportunity to present rebuttal, please stand for a minute. So please stand.
This dude behind him in the sweater looks like he's about ready to strangle the fuck out of him.
Attorney Opera, I did time both closings. You have 13:28 left.
Thank you, Judge. I don't think that'll be an issue. Folks, let me just say this. Mr. Brooks stands here and professes to speak to you from his heart. He plays on your sympathy. He talks about his children. He talks about the hardships that he's encountered and his family's encountered. And he brushes over the loss to the community. He wants to talk about how he's never held his newborn son. Never once acknowledges the Sorensen family, the Owen family, the Duran family, the Hospital family, the Kulik family, Sparks family. Never once. It's nice that Mr. Brooks can get letters from his loved ones. I don't know why he did this. I told you that. But actions define a person. It's that simple. You can stand with the Bible in your hands all day long and profess to be the finest man under God that you can be. But when you drive through a parade route and roll over children with band instruments to the extent that your vehicle heaves up and down, your intent is known, Mr. Brooks. It doesn't have to be guessed. It's known. You don't have to stand and wonder as he claims to. For him to keep going after he drove over those children in the band and have Jackson Sparks fly off the front hood of his car, lifeless, and keep going. And have Jane Kulik fly off the hood of his car, run her over, and keep going. I'm not going to go on. You get it. You need to look in the mirror, Mr. Brooks. If you want to accuse me of practicing my closing argument, you need to look in the mirror, sir. Your actions are that of a murderer. You murdered these 6 people. You endangered the safety of 61 others. There are 68 victims in this case, folks. That's not an accident. That's not a, gee, I woke up one day and don't know how I found myself in this position. If you have some explaining to do to your children, Mr. Brooks, I recommend you do it.
Fucking hell. I'm yes queening. Oh, fuck you and your objection.
Now, members of the jury, the duties of the parties and the court have been performed. The case has been argued by the parties. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 76 forms of verdict will be submitted to you concerning the charges against the defendant, Darrell E. Brooks. Count 1. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 2 of the
She's going to go through the full-on verdict of each and every charge.
Darrell E. Brooks, guilty of first-degree intentional homicide as
Obviously can't fast forward this. She's going to make this point here.
First-degree intentional homicide. Answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 3. One reading, we the jury find the defendant, Darrell E. Brooks, not
So while she's going through this, obviously if he decides to randomly object, I'll put on the
guilty of first-degree intentional
I'll raise the volume.
of the information.
But there's about
The defendant guilty of first-degree intentional homicide. Answer the following
30 pages left of jury instruction because more likely than not, she's going to talk about specific instructions about deliberation, and so on.
Count 4. One reading, we the jury find the defendant, Darrell E. not guilty of first-degree intentional.
But I'm already done with my first beer. I need a second.
Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 4 of the information. If you find the defendant guilty
But I do want to talk about
homicide, answer the following question, yes or no.
some of the parts that I missed,
First-degree intentional
or at least that I saw but wasn't able to watch with you guys.
reading, we the jury find
Um,
the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide.
the volume's intentionally low because it's really her just listing off the various verdicts that the jurors are going to provide. Victim impact statements, Jas, are only at sentencing.
Yes or no?
They wouldn't be
Intentional homicide.
part of the case in chief.
Count
Uh,
one reading. We the
yeah, so it's very mundane parts of the meat of what we're going to watch today was going to be the closing arguments.
we the jury find the defendant Daryl E. Brooks.
So I did on Friday. I did keep tabs.
If you find the
I'm trying to remember what was the big stuff on Friday.
or no,
I know there were several witnesses that were presented.
using a dangerous weapon. Count 7. One
I believe that's when he tried to bring his ex.
not guilty of first degree recklessly endangering safety.
That Friday.
Information. Another reading. We the jury find the defendant Daryl E. Brooks guilty
But then Monday,
of endangering safety. Information.
wait, was Fort
Find the defendant
Brooks on Friday or was it Monday?
answer the following question.
I think Fort Brooks was on Monday. That's when the judge.
Recklessly endangering safety while using a dangerous weapon. Count 8. One reading.
I'll probably look at the highlights. We'll probably take a look at the highlights of Friday and Monday.
As charged in count 8 of the information. Another reading. We the jury find the defendant Daryl E. Brooks guilty of first degree recklessly endangering safety as charged in count 8.
That's right. Friday was the sex offender reveal, the stare down.
For the following question, yes or no. Did the defendant
Monday when he his mother didn't show up and he
one reading
basically forfeited his right to testify.
Daryl E. Brooks not guilty of first degree recklessly endangering safety as
And also when they finalized the jury instructions.
we the jury find the defendant Daryl E. Brooks guilty of first degree recklessly endangering safety as charged in count 9 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 10. One reading. We the jury find the defendant Daryl E. Brooks not guilty of first degree recklessly endangering safety as charged in count 10 of the information. Another reading. We the jury find the defendant Daryl E. Brooks guilty of first degree recklessly endangering safety as charged in count 10 of the information. If you find the defendant guilty of first degree recklessly
Wait, he got the recall thing from his mother?
No.
Okay, I didn't know that.
Defendant commit first degree recklessly endangering safety while using a dangerous weapon. Count 11. One reading. We the jury find the defendant Daryl E. Brooks not guilty of first degree recklessly endangering.
What's my opinion about how the judge handled the case? I'll give my opinion
Another
today.
reading. We the jury find the defendant Daryl E. Brooks guilty of first degree recklessly endangering safety as charged in count 11 of the information. If you find the defendant guilty of first degree
Hey, Tones.
recklessly endangering safety, answer the following question yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 12. One reading. We the jury find the defendant Daryl E. Brooks not guilty of first degree recklessly endangering safety as charged in count 12 of the information. Another reading. We the jury find the defendant Daryl E. Brooks guilty of first degree recklessly endangering safety as charged in count 12 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 13. One reading. We the jury find the defendant Daryl E. Brooks not guilty of first degree recklessly endangering safety as charged in count 13 of the information. Another reading. We the jury find the defendant Daryl E. Brooks guilty of first degree recklessly endangering safety as charged in count 13 of the information. If you find the defendant guilty of first degree recklessly endangering safety,
Okay,
question.
I'm gonna let this play in the background. I'll just keep tabs of it in the while it's going. But I'm gonna go back to I'm gonna go to the highlights from Law and Crime Network. I saw this one. Ah.
It has the ability to question you about that without having that letter.
So this, I believe, is after she stopped the so this is Friday. Yeah. So this is after she stopped the testimony between him and the ex when the baby pictures came out.
So
The state has the ability to question you about that, or question this witness, and to look at the veracity of what your claims are here. So, I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning. Do you have the letter with you in court?
I just said no. How
Okay.
many times I gotta say the same thing on record?
You know, sometimes, sir, I
Oh, wait, so are those the pictures of his newborn?
don't hear what you say.
Yeah, Danny, I will. Danny was asking if I'm going to cover the rest of what happened today, and yes, we'll lead all the way back up to what happened this morning, and into this afternoon. But I wanted to start with Friday since, you know, that's when I hadn't watched it yet.
Say because you interrupt me so much, or you answer quietly. And I'm taking notes, and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear
In
that
a
just
quiet
fine.
courtroom,
And
yes,
everybody
we can hear it very
and
clearly.
everybody assumes that it has to be disparaging. Or,
Once again, you're doing this tactic.
Because
it's
not a tactic, it's facts.
What we're
It's
talking
facts.
about to some other reason.
It's facts.
to
Because
some
I
other
find
thing.
it hard to
Oh my fuck! That was his grandchild. His 15-year-old kid had a kid. Oh.
believe that
I'm going to
all
let
of
the
a sudden
state.
nobody hears what I say.
I'm going to let the
Come on,
state
man,
make
stop.
a record of why they
Stop.
believe it's objectionable, because I haven't let them do that. I've given you multiple opportunities to tell me why you
So
believe
I
it's.
didn't get these pictures from nobody else. Why was
The
somebody
record will
else
reflect you have 2 pictures that you believe were from this witness.
that I know is from him?
No, that you believe.
That I know.
All right, I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
That's a lie. I object to
Let
that.
the state make their argument without interruption, sir.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question,
It doesn't make her a bad witness, because even assuming if it's true, which is not, even it's bad character evidence that doesn't really go to deceit, trustworthiness, or deception.
he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I object to that.
I'm not
because
done.
that's a lie.
Let
Because
him-
at the
I'm not
end of the
done.
day,
Let
if
him
we-
finish,
If we gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so
Oh, he
much.
mad.
Once
So
again,
we can
Mr.
open
Triggered.
The
Brooks
door
is
on,
being
we can
loud,
open the door on how old she told me
disrespectful,
she was when we met.
interrupting.
We can ask
He's-
that question
he is
too then.
over the
Did you
top
ask that?
animated
Do you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the
No,
state
this-
Gary, yes, that's basically a nicer way of saying statutory rape.
No, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he
No, the jury's not here at this point.
it is inadmissible. She will not be questioned. And under 906.11, I will declare the cross-examination closed. Thank you. We're in recess. 1 hour. Another
Get your
reading.
facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know?
They always say, but she said she was 18. They always say that. What would have changed if she had tasered him? She had him tasered at any point while the jury is out? I honestly don't know, Kit.
I will advise you that if you are in that courtroom, because I have put you there and you have not reclaimed the right to be present.
Yeah, I've never heard the
Asking
golden
and
eagle
then,
argument either.
Expressing a willingness to conduct yourself consistently with decorum and respect inherent in the concepts of courts and judicial proceedings, you will remain over there. And it looks like he took his headphones off, so I will. Mr. Brooks, I'm advising you that if you fail to call a witness, you will forfeit your right to present any additional witnesses. And I'm doing this outside the presence of the jury right now for a reason. I need to know from you right now, you are unmuted, who is your next witness?
She trying to say something to me? Yeah.
What you trying to say?
That was very disrespectful, sir. You chose to take off your headphones? You
Yeah,
choose
because
to
I'm
read?
muted. I'm muted. So why am I gonna have my headphones on and I'm muted?
Well, I would think your headphones help you hear. The
They
muting
do.
is so that I don't have to hear the disruptions.
Okay, well then why should I need to hear what
So
you
let
saying?
me be clear, sir. And
You
you
don't
are
gotta
not.
be clear or nothing. I don't gotta listen to you.
I will ask you one last time, sir.
Temper tantrum.
Who is your next witness?
First of all, is she talking to me again?
He.
So
This.
we gotta keep doing this little childish stuff, dude.
You're the one who's been acting like a child so far.
Abide by every single rule, but don't nobody else gotta do that.
The record should
Judicial misconduct.
reflect that Mr. Brooks
Repeatedly.
is spouting off, making
I think
unsubstantiated
the record can hear me. I
allegations
think they can hear me.
against this court,
Unless I'm
directly
muted.
attacking the integrity of this court and these proceedings, while yet
This court ain't got no
refusing
integrity.
to answer
This court don't have
simple
no
questions. Mr. Brooks, you
That's
are,
not my name. I told you I don't consent to being called that name.
sir, you are hereby advised this is the last time I will ask this question,
Don't talk
or
to me
you
like
will
that.
forfeit your right to present
Can't do that.
any
Show me what-
additional
show me
witnesses,
where that's law.
because
Show
you
me
are
where
not
that's law.
cooperating with this process.
Show me that it's law. That's all I'm asking. Show me that it's lawful law.
Mr. Brooks,
How can I forfeit not being able to have a defense? Are you kidding me?
Your conduct. That's what happens. Your conduct. If you, I mean, everybody keeps on mentioning this. Any attorney who's been acting like this not only would have been held in contempt, but they probably would be disbarred if they showed this level of disrespect and insubordination to the court. The only reason why he's been able to get away, and I use this in quotes, get away with what he's doing, is because one, he's already in custody. And it will remain in custody for the duration of the trial. And so holding him in contempt doesn't really do anything. And two, because he is representing himself, so there's the judge is giving him a little bit of leeway in that regard. So those things combined, the judge is limited in what she's able to do to rein him in. The best she can do right now, Gary, she can fine him, but do you really think this motherfucker has a job or assets? He ain't got shit. So fining him ain't gonna do anything. So right now, putting him in the timeout room with a mute button is the best she's able to do.
All I'm asking is that you conduct yourself.
And Danny
with
just updated me that the judge is only on charge 32, so we're not even halfway through.
With decorum and with respect. I will gladly bring you back into this courtroom so you can present your additional witnesses. But you need to ask me to come back into this courtroom.
With all due respect, I'm tired of having this back and forth with you every day. It's not my intention to come in here and have these interactions with you every day. It's not. Regardless to what you may think, regardless to how you may feel, that is not my intention. Okay?
By the way, the echo is from the original video.
Okay? I simply do what I do because I do not have the understanding. So if I don't understand something, I'm going to ask a question.
Guys, the echo is from the original video.
I apologize if it makes you feel that I'm intentionally trying to delay the proceedings. If I'm intentionally trying to be disruptive. Because that's not the case. And I feel very, 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 very disrespected every time the record is made, making it seem like that's what I'm attempting to do. So of course it's gonna frustrate. Of course it's gonna make me a little bit upset. And I just want you to understand that. It seems to me the way I'm interpreting what you're doing, it is your courtroom. That's not it. That's not a dispute. That's not up for debate. You control what's going on in there. That's not a dispute. But the way I'm interpreting what you're doing is that I'm being held in contempt. That's how I'm interpreting. Because one of the three things that's cited in the Illinois versus Allen, one of them is being gagged.
Hey, Yuko, thank you.
I haven't been gagged. One of them is held in contempt.
What's the third, Mr. Brooks? What's the third?
The third is removed from the courtroom while the trial continues, right? That's the third, right?
And that's what's been done.
Okay. So now, where does it say after that having me on a headset or being able to see and hear and all this and this, how is that not prejudicing my defense?
Sir, you can raise that issue on appeal. You can raise that issue on appeal if you are convicted.
This is why I say that though, because I can't even see. The only thing I can see right now when I'm looking at the TV is you and the prosecution table. I can't see anything else.
I understand that, sir. I'm fully aware of that.
So I'm not fully aware of what's going on in the courtroom. Don't I deserve that right to be able to see and hear everything that's going on?
If you can conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, the answer then is yes. So I'm not going to have a debate with you about the law. I will ask you again, would you like to come back into this courtroom?
Are you going to kick me out?
Sir, I'm asking the questions right now. Would you like to come back into this courtroom? Yes or no?
Are you going to kick me out?
Sir, it's a yes or no question. Would you like to come
Well,
back
my
into
answer,
this?
my answer was based on the reason why I'm answering like that is because the moment I say something, it's gonna get me put out. I don't want to keep hauling this stuff back and forth and back and forth and back and forth and back and forth.
Well, usually it's due to your actions that result in you going back and forth, back and forth.
It wastes his time, really.
I'm well aware of that.
Tommy Thomas, he'd bitch if his ice cream was cold.
But then it's laid at my feet as if that's my attempt. You think I want to be over here?
Sir, I don't know what you want or don't want at this time. I know that we need to complete this trial and that you have frustrated today more than ever before the ability of this court to do that.
Well, I apologize for you feeling that way, but I'm frustrated too. And nobody seems to take that into account. I'm just as frustrated as everybody. Probably more.
Then I suggest that you conform your conduct to the requirements of courtesy and decorum so that you don't run the risk of forfeiting your right to be
Also
present.
true, it's not as
But
if
that
he's the
falls
one who's
on
actually
you
carrying
and
this
you
stuff,
alone, sir.
like Blandino.
I don't understand what you mean by that. I really don't.
Mr. Brooks, you may not understand it. I don't think that's accurate. I think you know exactly what you're doing.
Yep.
If that's what you think, that's fine. I can't argue
And
with
you have
about your
demonstrated
opinion.
throughout this case that you pay attention to witnesses' testimony, that you make cogent and coherent objections, at times that you have even had evidence suppressed in this case or stricken. That's the word I used during this case. You made an opening statement. You communicate with witnesses. So
Your
you
Honor,
clearly
it's
read,
not
write,
fair.
and understand English. That's not an issue
not-
here, sir.
It's not fair
Are
to
you
say-
self-represented? Absolutely. Does that present difficulties and disadvantages? Absolutely. But that takes me back to when you waived your right to counsel. And you did so knowingly, freely, voluntarily, and with a full understanding of the disadvantages and advantages of doing so, meaning advantages of having an attorney, the disadvantages of doing it on your own, and you made a deliberate decision to
Your Honor, that's
represent
not fair.
yourself, and that comes at a risk to you of, yes, at times not fully understanding the law, the rules of evidence, the rules of procedure, but you do
not
so
fair.
at your peril.
That's not fair to state, Your Honor, because
So I'm going to do the
paperwork came-
following, since I'm not really getting anywhere. I'm going to mute you for the moment. I'm not getting anywhere with him. I would like him to be brought over, and he has a choice to make. He can come back over or he doesn't. Either way, he's going to be asked to call a witness in front of the jury. I will ask him 3 times if he fails to give me a direct answer, and after the 3rd time, I will make the appropriate finding, but I will do that outside the presence of the jury. But we are going to continue. So we'll go off the record, and he will come back over here. Thank you. We are in recess until that happens.
So for me, real briefly before we get to the next clip. You know, my dad, when we were on vacation and we were talking about this case, you know, my dad said, like, the best thing that he could have done is, you know, admit to what he did and throw himself at the mercy of the court, type of thing. You know, I did it. I was in a rage. I was in an uncontrollable rage. And I'm at least show acknowledgement of what he did and some level of remorse and responsibility. And I honestly feel like that might, it wouldn't help his sentencing, because even then I would still say he deserves all the life sentences. But it probably wouldn't make people as ragey as they are now with how he's acting in this moment. The way he's acting right now is making people despise him far and away more than had he at least admitted to his wrongdoing and begged for mercy. he doesn't deserve it. Don't get me wrong. He doesn't deserve it because he ultimately has to face the responsibility of his actions. But he probably wouldn't be facing this level of vitriol against him. I didn't watch this, but I did see this this thumbnail where he was mean mugging the judge.
Mr. Brooks.
So I'm the only one. I got one.
Mr.
I got
Brooks.
one ear that work, and I heard that.
This
Come on,
is
man.
to benefit
man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit
witness
me, so let's be
has
clear
a
about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record of
voice
Abel
just for
Lescott.
that.
Stop talking.
Come on, man. Like, I don't know who y'all be thinking y'all fooling. I accept the value in return for value this document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what
1 second. Sorry. Original Vintage, thank you for the $5 Australian. How do you think he'll react to the life sentences? Think this will go flying when it sinks in that the party's over? You know, I don't know. I mean, given that this guy obviously has a temper, he may well make a scene out of it. So I can actually see that happening. I don't know if fists will go flying, but I can see him making a scene out of it.
I want to do. Do not interrupt Attorney Opera.
So can
Your
you
Honor,
tell,
I
can
believe
you
he
explain?
has 7 prior criminal convictions via OWI 2nd from 1997, and OWI 3rd from 1997, and OWI 4th from 2003, criminal trespass to dwelling from 2006.
Right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break.
Danny's like, I hope they pull the jurors. I hope they do too.
I will advise you.
Wait. But if they do that, then that'll take all fucking day, though. If they pull the jurors on every single charge, I mean, I would appreciate it, but damn, that would take us all day.
You want to run the record back?
Mr. Brooks.
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
This
Come on,
is
man.
to benefit
Come on, man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your...
this. How are some of these answers allowed to
76 charges, yes.
They're coming straight from reports made by the people on the stand. Very curious.
I don't understand your question. I'm not sure what you're asking me.
What I'm asking is, reading from the report that the people on the stand are giving, the report that they gave to law enforcement.
I think I remember this part. He thinks that the all the jurors were or some of the jurors were like fucking coached on what to say precisely while they were on the stand. I think this is what he's complaining about. Witnesses. Did I say jurors? Witnesses. That's what I mean.
If you're asking me whether there's a mechanism in the rules of evidence and how to establish that before the jury, the answer to that is yes. If you're asking me how you do that, I'm not going to answer that.
Right? I didn't ask how.
Akira, thank you for the 199 super chat. He's facing 6 life sentences due to the 6 people he allegedly killed, murdered.
To be blunt, which I've been since the beginning of this trial, obviously, I see the whole strategy here by the prosecution. I see right through it. Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Well, that is completely speculative on your part without
It's
any
obvious.
basis in law or
It's
fact.
obvious.
Sir, you could ask questions that establish that. You can ask them if they've met with anyone. You haven't done that. So for you to say that right now is without basis. If you want to...
It's clear.
If you are looking to elicit what they said in the report, there is a way under the rules of evidence based upon the way the witnesses have answered to clarify that, but that requires you to call certain witnesses. I'm not going to give you any
I don't
more
think I have
legal
to- I don't
advice
think I have
further
to-
than that.
I don't think I have to
So
call any other witnesses that's
if
not
you're
on the
asking me to
stand.
strike their testimony based on
I
your
didn't say
perceived,
anything
then that's
about that.
all right. Then I'm going to bring the jury back out, and you're going to call your next witness. So I'm
So
not
is you-
hearing a request from you at this time. You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the
You're
people getting on the
assuming they
stand?
spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir. Again, you could ask
All of a
questions to
sudden,
lay a foundation
all of a sudden the
with
state
these
don't got.
witnesses.
All of a sudden, for the first time in trial, all of a sudden now they don't got no.
God, why?
A just super chatted with 99.99. They said better late than never. Glad to see you back, Artie.
Thank you, RA, for the $99.99 super chat. Holy shit. Thank you. Oh my God, for waking me up. I mean, by the way, I'm also operating on 4 hours of sleep right now. But thank you for waking me up. Jake, the jump scares are at $100, but I noticed that YouTube will count 1 cent below the whole number as part of that next tier of super chat. So I changed the requirement to 99.99 just to be fair to people who wanted to do the jump scare.
Hurry up. We just gonna let these people go.
And it's for that, and it's that way for all the other tiers as
This
well.
is argument on your part,
I
sir.
see
It
through
is pure
I
commentary
just
at
want
this
that on the
point.
record. I see through it.
And your
Nice try,
see-through
but I see through it.
has absolutely no basis in
Yeah,
fact.
I know that's what's being done.
You
Come
could
on, man.
ask these questions. You could
Come on,
ask
man.
these
Got the right
witnesses
one.
certain questions, and
I'm
you're
far,
not.
I'm far from an idiot.
They're your witnesses, sir. If you believe,
So I'm gonna start asking every witness up here that they seem just to mysteriously now not have any cross for. Have they been coached to answer the way they answer? Because
well, you can't
I
ask
find-
that, but
I
you can
find
ask
it
them
very
if they've
funny.
met with anyone ahead of
I
their
find it
testimony
very
here
funny.
today,
I find
which
it
you've
very
done
funny.
with other witnesses.
I find it very funny that these are their reports, and now all of a sudden you can. Oh, I saw the person in the car. Oh, but
Mr. Brooks.
I saw the police or something. Oh,
He's
I don't recall what.
The level of salt he's exuding right now is palpable.
They had on.
Mr. Brooks,
You can
there's no
recall seeing
purpose
somebody
for you
reach for
saying
something
this
and
right
don't
now.
know what they had on. I find that
All right,
very.
I'm having the jury brought
man.
out. I'm instructing you to
Come on,
avoid
man.
the commentary when the jury comes out, or you will
I didn't
forfeit
say-
your right to be
I didn't say
present.
nothing.
Before we do that, there's an issue that we do need to take up potential as to a witness
Brooks, guilty
by the
of
name of
first
Abel
degree,
Lescano.
recklessly
He has
endangering
prior
safety
criminal
is
history.
charged.
Thank you.
She's still going.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had
of
to be
the-
said. So it's the defendant.
He's so mad at the fucking tone. He really he really does not like it when females are acting up. They're acting all uppity. He really doesn't like them females acting all uppity in front of him.
That's not how it was said.
That was how I
completely
said. You want to
disagree.
run the record back?
Mr. Brooks.
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
This
Come on,
is
man.
to benefit
Come on, man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit
witness
me, so let's
has
be
a
clear about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record of
voice
Abel
just for
Lescano.
that.
Stop talking.
Come on, man. Like I don't know who y'all be thinking y'all fooling. I accept the value in return for value. This document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opera.
So can
Your
you
Honor,
tell?
I
can you
believe he
split?
has 7 prior criminal convictions.
I think this includes his mean mugging. Yeah. So they included this part in addition to what we already just saw.
I'm going to directly be speaking with him, and if he's unable to hear me, to put on the headphones at this point. He's unmuted.
Thank you, RA. Have a good one.
I've also been advised by...
And Danny just updated me that we're on count 63 so far in the verdict reading.
not just the bailiffs who are over there who I can hear through the audio, but also from the clerk who's in that courtroom, through my clerk who's in this courtroom, that the audio is very loud and clear.
This is now, okay, now we're at on Monday.
Mr. Brooks, I would like to go through with you your right to testify and your right not to testify. We are at the stage in the proceedings where it is important that this court conduct a colloquy with you. I will advise you that if you refuse to answer my questions, refuse to acknowledge me, you can forfeit your right to testify on your own behalf. Again, that's State versus Anthony, 2015, Wisconsin, 20. Mr. Brooks, you need to be aware and are so advised that you have a constitutional right to testify. Did you hear me say that? There's no response by Mr. Brooks, and he does not have the headphones on, and he has a book in front of him, although I haven't seen a page turned. If you testify, sir, the state has the right to cross-examine you. That means to ask you questions after you give your initial testimony. Did you hear me advise you of that? No response by Mr. Brooks. Sir, you also have a constitutional right not to testify. If you decide not to testify, you are further advised that doing so cannot be used against you, and I would so advise the jury. Did you hear me advise you of that?
Oh yeah, this is where he's like,
response by Mr. Brooks.
he's fake reading the Bible.
The decision to testify is for you and you alone to make. Did you hear me say that?
He doesn't answer the questions, and yet he wonders why
No
the judge,
response by Mr. Brooks.
why the judge said he forfeited his right to
My
testify.
understanding that Mr. Brooks has the equivalent of a 12th grade education, that he attended school either up to or through 12th grade, and either has a GED or an HSED. There's been some conflicting information on paperwork throughout this case, but I'll find that he does have a high school education. He is currently...
Okay, so yes, while he is looking through the Bible, I think Danny over the weekend raised a great theory that I actually kind of ascribe to. That Danny postulated the theory that whichever guru that he's getting this information from, they're writing the notes in the Bible, because the Bible is Waukesha County Jail property, and it may very well be that whatever notes or paperwork or script that he has, it's in the Bible, and that's what he's reading, and not the actual passages itself. Which I actually think is probably, yeah, I think that's true. I think that's a very, very plausible theory.
currently in custody, of course, at the Waukesha County Jail. I'm not aware of any medication that he has been taking. Sir, have you taken any medication within the last 24 hours, or any drugs or any alcohol? I'm not receiving a response to that. I'm aware that he's able to read and write English. I would refer back to the record made during my colloquy with him regarding the waiver of counsel and his ability.
Why can't I be as smart as her? because she's awesome in every way.
To be aware of rights, his ability to, I made a finding at that point of his understanding, and based upon his conduct throughout this trial, including the waiver of right to attorney hearing, I'll make a finding that he has the ability and understand, he can read, write, and understand the English language.
Am I unmuted?
You've been unmuted the entire time, sir.
So what are you talking about? Is you talking about subject matter jurisdiction and how you going to verify it on record?
So he
Prove it on record?
did not answer my question if the record's not clear about whether he's had any drugs, alcohol, or medication within the last 24 hours. I'll ask him, sir, has anyone made any threats against you to influence your decision on whether to testify on your behalf in this trial? Although he turned and said, what did you say? Again, I believe he's fully able to hear this court at this time based upon how the audio is functioning in the other courtroom. He did not respond to that. Has anyone made any promises to you to influence your decision?
You saying. So if you can hear me, I don't hear everything you saying, and you know I don't hear everything you saying. So cut the crap.
Mr. Brooks has interrupted with very disrespectful.
I mean, it's also very possible. You're right.
I'm going to direct.
What do you say? Who said it? Woodwork. You're right. Jails generally are pretty strict when it comes to notes and note sharing. So, I mean, it is possible that it may not be the case, but I think the best way of being able to do it for him to take notes would be within the Bible. So say, for example, that he had like the script on him, or that he got the script from the guru. It could be that instead of taking those actual notes with him, that he wrote them down in the Bible for him to reference later on. But I mean, let's be real with each other. Nobody here believes for a second that this guy's actually looking into the Bible for guidance and knowledge and reflection, right?
If the bailiff could confirm, well, he put him on top, he put him on the floor. That's his right. They're not in front of him, but it's by his own conduct that he's done that. The record should reflect Mr. Brooks is muted because he wants to continue to debate with this court about my prior rulings regarding his forfeiture by conduct of his right to present further evidence on his behalf. I know one of the things I probably need to look at, I'm not sure if Madam Clerk did this or not, would be the language from the amendment from the amended information on count 70. Turn a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree.
I think we're done with the verdict count.
When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the parties before answering, so it may take some time. You should continue your deliberations while
I'll take
you
that under advisement
and answer.
Under advisement.
The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, The presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdicts will be read into the record in open court. The court may ask each of you if you agree with the verdicts. Before I swear the officers, we will determine the alternates, and then I will have all of the civilian bailiffs and deputy bailiffs that will be in charge of the jury during their deliberations and sequestration.
Wait, hold on.
Yeah, let's put it over here.
Okay.
I have a lot of stuff up here. Let me push that in. There we go. I counted and recounted 15.
She's selecting the alternates right now.
So we have placed each one of your numbers in the tumbler. I'm going to draw 3 numbers. Those numbers will be the alternates, who will nonetheless be sequestered in the event we would need to call upon one of you to replace another juror. The first number that I am pulling out is 10.
I know, right, Jake? This feels so archaic, but
30.
also traditional in the same sense. Having a freaking, raffle device like you would see at a bingo lot.
I'm going to confirm that I still have 12. I know Madam Clerk did it, but I will also do that to be sure. And I just confirmed.
Oh yeah, it has worked.
In there.
I'm not saying it's broken, but I'm saying it's a very old timey look at the system.
I will need all of the deputies and civilian bailiffs to come up and be sworn on the record for the sequestration, and I'll go ahead and do it.
And for those who have been wondering, yes, the jury will be sequestered for the evening. They'll be put up in hotel rooms for the night.
Clerk of Court Todd, why don't you join them just in case you're needed?
Yeah, Gary, apparently they do have civilian bailiffs. I don't know how that works. Again,
All right,
I'm not a Wisconsin attorney.
Your right hand. Do you swear that you will keep all jurors on this trial together in some private and convenient place, and that you will not allow any person to speak to them or you speak to them yourself, except to ask whether they have agreed on their verdict, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God? All right, and then Madam Clerk will just make a record of who you all are. It will take us a moment just to have all the finalized paperwork to go back with the jury. I do have all of the verdict forms, if I want to get that to Jen.
Gary, I highly doubt it. In most instances, jury deliberations happen within regular, operating hours, so that if and when there's a verdict, everybody's available to be
Well,
brought in to hear the verdict reading.
6:24. All rise for the jury as they're excused to begin their deliberations.
Oh, wait, they are? Wait, are they actually beginning their deliberations? I thought that they... Okay, maybe I'm wrong.
We'll make a record of what she did previously. But
Yeah, I'm gonna need all of them, and then I'll
yeah,
take
no,
them
I know.
down and all
But
that
those are
stuff.
the...
Yeah.
Okay, for those who have been asking me what I think, how long it'll take, for me is my over-under is an hour.
All right, thank you. You may be seated. Just so the record is clear, the alternates, of course, will not be participating in the deliberations. They will be in a separate jury deliberation room and will only be called upon if needed, of course, after consultation with the parties.
The reason I say an
As how late
hour.
I will let them deliberate tonight. We have ordered dinner for them. I believe it will be here shortly. And I really will leave it up to them as to how late they want to deliberate before they would want a break and then to retire for the evening.
Okay.
Under a sequestration.
Okay, that I had no idea. I didn't realize it was up to them to determine whether or not they wanted to retire for the night. So I had no idea.
Order, so they will be kept separate and apart. Their electronics have been confiscated, and they will not be going home until verdicts have been reached or they are discharged from the court, whichever would occur sooner. Anything?
My thing. The reason. Let me put it this way. The reason why I put an hour is purely because if I'm under the assumption that they're going to all find him guilty. But I imagine that it's going to take an hour to go through each and every charge saying, okay, can I get a vote on charge 1? Can I get a vote on charge 2? And they'll might discuss a bit of the evidence. They may not. But I would say that's why I would say it's about an hour, maybe 2 hours. That's how long it'll take.
Anything else the parties would want me to address at this moment? From the state?
Thank you, Judge.
Anything from you, sir?
Yep. So essentially, I'm gonna have to stay here while they're delivering. I'm gonna be able to go back to my unit, use the phone, shower. It is shower day for my pod. We only get 2 shower days. A week.
So here's what could happen, though, sir. I don't have a problem with you doing that, but they could have questions.
Damn it,
And then-
I had to leave. I had to go. I'll be right back.
And then you would need to become available so we could address any questions. They may ask for exhibits, things of that nature. So as long as you're willing to come back for those things, I don't have an issue if, I probably should talk to the COs or at least the sheriff and make sure I'm not stepping on their toes since they're in charge of all of that. But it's possible that we get a request for exhibits, some exhibits initially. I wouldn't be surprised if we got that. So let me do this. Let me confer with the sheriff's department. I don't initially see an issue with that, but I want to make sure that they have a protocol in place and that's what they would like to do as well, okay?
And one more thing.
Go ahead.
I was curious. 61 charges for the reckless. 61 injured parties did not testify. So how does that work? How essentially how are charges able to be charged if all of the injured parties did not testify?
From my perspective, sir, the state presented their theory of the case, and there was sufficient evidence regarding the charges.
By the way, guys, look what I got in the mail.
I can't further explain it from there because that would require me to explain.
An Elder Scrolls crate.
And I guess that's all I can really say about it at this point.
I got a point though.
I'm sorry?
I got a point, though.
I'm not going to comment on that, sir. Of course, the state bears the burden of proof, and they have to convince a jury beyond a reasonable...
Okay, apparently I missed the question. Hold on. Darn it.
61 charges for the reckless. 61 injured parties did not testify. So how does that work? How
Oh my fucking God.
How essentially how are charges able to be charged if all of the injured parties did not testify?
From my perspective, sir, the state presented their theory of the case, and there was sufficient evidence regarding the charges to go forward to the jury. I can't further explain it from there because that would, for me, that would require me to explain the law. And I guess that's all I can really say.
Okay, so he doesn't understand that the charge, and this is what they explained at the very beginning of this trial, that the charge of recklessly endangering safety does not require proof of injury. Injury is not required. All they needed was witness testimony to show that this person was there, this person was there, this victim was there, this person was there, this person was there, this person was there for each and every one of those charges. So they did not need every single person who would be a victim of that charge of recklessly endangering safety of X, Y, and Z person. They didn't need them on the stand for each and every one. They needed a witness who observed it, and the prosecution had that person testify as a witness to what they observed. That's why they didn't need all 60 plus people who were actually injured in the incident to testify. That's why you didn't need doctors and medical examiners to talk about the specific injuries of each and every one of the persons, because the charge of recklessly endangering safety does not require physical injury to transpire.
Say about it at this point.
I got a point, though.
I'm sorry?
I got a point, though.
I'm not going to comment on that, sir. Of course, the state bears the burden of proof.
Oh, fuck!
And they
Okay, he can go fuck himself with this sort of like coy, boyish grin on his fucking face after giving his fucking woe is me closing arguments.
have to convince a jury beyond a reasonable doubt. For better or for worse, sir, I was not presented with any motions to dismiss, either at the end of the state's case or the close of the evidence.
Which I said he could have done. He wasn't going to succeed, mind you. He could have done that.
Regarding any legal arguments you may have had regarding those issues. And so at this point, the jury has the case, and they will determine their verdicts. If there are issues of law that you want to raise after the verdicts are received, then you'll have to make that determination.
Yeah, that has to be raised, because essentially you can't, if no injured party testifies, then there shouldn't be a charge.
I disagree with that characterization, sir, but there is frankly no motion in front of me based in law or fact, so for me to comment any further would require me to give an advisory opinion, which I'm not willing to do.
So you saying I need to make a motion?
So
Yes,
what I
dumb
would say
fuck!
At this point is I do have one issue that I would like to raise with the parties. I frankly I need a break a little bit. I mean, obviously the court has to stay open. I know my dinner is coming, and I think it's reasonable. I need to put a few things together, but I do need to make a record of some information that I received earlier today, so that the parties are advised of that. But I will do that. Let me confer with the Sheriff's Department about your requests. I'd like to take about in about 30 minutes, address the issues that I need to address, or the issue. And I want to find out if
begging
that
to be
would
slapped.
interfere with
Generosity
your request
towards
about
others
taking a shower and all of that.
Not this time. By the way,
If you can hold tight and stay
Sorry.
with us for a little bit, that would be great, and I'll confer with the Sheriff's Department and have a more definitive answer for you shortly, okay?
Can I get my filings?
You want you want the originals back. If Madam Clerk has scanned them all in and they're uploaded, I don't have an issue giving you the originals back. They will have the date stamp. They don't have a time because
Backpfeifengesicht. That's what he has right now. Backpfeifengesicht. Gesicht. Punchable face.
Also, so that they were in there, printed them after I scanned them in, so it has a document number.
So you're getting 2 copies. You'll have that, okay?
See, I didn't interrupt you. See,
I'm sorry?
I said, see, I didn't interrupt you.
Thank you, I appreciate that. Unless I would like the parties back in about a half an hour. Thank you, unless they have a question sooner.
All right, so we're all right, so we're now back here. All right, we're gonna go back to the
Backpfeifengesicht.
there you go. Fuck this guy. All right, we're gonna go back to his attempt at playing Fortnite IRL that happened on was it Monday? Yeah, Monday.
No, I don't want to do that. Oh, you don't? I changed, hold on. 76. The 76 count. Just want to make. It says near Frame Park, so it is in there. But that was just one question I had. All right. So, state have any requests as it relates to the jury instructions?
I'm just going through each one. I'm on page 50 of 107. Everything's looking great so far.
Okay. Fair enough. There's 107 pages. I certainly can give the parties some time to continue to read through them.
I put 325, 141, and 172 at the end because I wasn't sure.
Honestly, I'm surprised he didn't ask the bailiffs for a blanket to cover himself with the fort. And pillows, yes. With a fucking handmade sign that says "No girls allowed."
Mr. Brooks is requesting to go back to his cell. At this point, I'm going to deny that request. He can remain in the other courtroom.
Fort Tackett. Nice. Make sure his channel meme. I'll try it. I mean, there are plenty of memes to get out of this case. I'll have to reach out to Mandy to figure out what sort of sound bites we need to use. Not a lot. But yes, Danny does note that apparently he learned how to pronounce Tackett this time as Tacit. He did learn that. Well, we'll get to that later on today.
I know he's muted, but I can certainly hear him from this side. He appears to be yelling at the top of his lungs. I can't decipher what he's yelling.
need to get something to eat. B.A. Solas, thank you for the 1337 for the leet tip.
I'm going to directly be speaking.
Thank you very much.
If the bailiff could confirm, well, he put him on top, he put him on the floor. That's his right. They're not in front of him, but it's by his own conduct that he's done that. Do you have any requests
First of all,
related
what?
to the jury instructions, sir?
I will also give my personal assessment of the judge throughout this endeavor after we're done catching up through today's festivities.
Man, yeah, I got requests. It ain't like they gonna be honored though.
As it relates to the jury instructions, sir, what are your...
I heard what the hell you said, man.
Well, Mr. Brooks, that was very disrespectful.
Yeah, and I've been getting disrespected since the beginning of this whole process. So welcome to the club.
He
Mr.
mad.
Brooks, do you have any
I'm
requests?
tired of my rights being trampled on here too. I'm tired of it too.
Do you have any requests as it relates to the jury instructions?
Ain't nobody understand why I'm frustrated. How you gonna sit up here and make decisions based on what you think I said when I didn't get consent for you to do any such thing?
Sir, I understand you may be upset, and I really do,
No, you
but
don't
I've made my
understand
determinations.
nothing. You don't understand nothing. You don't understand anything, Your Honor. You don't. Because
I'm going to mute him again because he's not answering the questions that I'm very clearly asking him, and I've given him 5 opportunities. Mr. Brooks, do you have any requests as it relates to the jury instructions? I'll unmute you for that answer.
I can't hear everything you're saying.
Mr. Brooks, I know the audio's turned up. I believe you can hear me. You've chosen not to put the headphones on. That's your choice. My final question to you, do you have any requests as it relates to the jury instructions?
I just told you, am I muted? Am I muted?
No.
I just told you, I don't know how many times, I can't hear everything you're saying.
Then you should put the headphones on.
Don't you understand? What about that don't you understand? Did you see headphones? You can see everything. You can see boxes, but then you see headphones.
Have you asked for headphones to...
I mean, in all seriousness, I get this angy when I'm in a multiplayer game and I'm losing, and even then it's still childish. It's still embarrassing whenever I get this angry. I at least acknowledge that much. But that's because I'm also playing a fucking video game.
To be provided, sir?
I should have to ask him. I asked for my boxes to be moved.
I believe they took them away previously because you were so agitated they were perhaps afraid you might break
Yeah,
them.
I'm still agitated. I ain't gonna stop being agitated.
But also, at the same time, I'm not screaming at a fucking judge. I'm screaming at the game, the opponent, or myself. You know, not somebody in a position of authority.
I ain't gonna stop. Sit up here and do everything you're doing. And think you're gonna, and think God...
Cracking me up. Thank you for the $5. Should have had a Snickers.
You ought to be ashamed of yourself.
Mr. Brooks, do you have any requests as it relates to the jury
Yeah,
instructions?
I can hear what you're saying. I can hear what you're saying.
Oh my
You
God.
just told me you didn't.
Yeah, I got the headphones on. You can't see that?
What are your requests as it relates? What are your requests as it relates to the jury instructions, sir?
Man, don't try to come with this whole little image of sir. Now it's all this sir and all this. I'm gonna get where I'm going. Try to put on this little act like you so worried about what's going on with me. You don't give a damn. Never did.
Mr. Brooks, you're being disrespectful again.
I did see the audio engineer testify.
You've been being disrespectful.
I need to know what your position is regarding the jury instructions. And I need to know it now.
What you mean? Who you talking to?
I'm talking to you. I need to know whether you have any requests as it relates to the jury instructions, sir.
Yeah, first of all, why am I charged with 2 bail jumpings when I was already charged in Milwaukee for the same bail jumping? That's double jeopardy.
That's not double jeopardy. Your
That's not double jeopardy.
objection is noted. It's overruled.
It is double jeopardy. How you gonna charge me with the same charge that I'm already charged with? You can't do that. The Fifth Amendment says that you can't place somebody in jeopardy of life and limb twice. I'm already charged with the same count in Milwaukee. For the same case. It's the same bail jumping charge. So how am I charged with that here?
All right, mate.
Sir, I'm not going to provide a legal...
Okay, so she doesn't respond to that. The way it would work, again, based upon the Supreme Court, if I recall, I can be wrong. Look to Natalie for confirmation. My understanding is that double jeopardy does not latch. I should say latch. Double jeopardy does not latch. My understanding until the first witness is put on the stand in a trial. So the fact that he has pending charges in Milwaukee is inapposite, whether or not he's got these charges here in Waukesha. So regardless of what his charges are in Milwaukee, the Milwaukee charges are the things that he can argue that can be dismissed for double jeopardy. Not the Waukesha charges. The Waukesha charges are the ones that are being acted upon. Right? So he can bitch and moan about the Milwaukee charges being dismissed under double jeopardy, not the charges that are being acted upon here and now.
Explanation other than to say I've reviewed that. Your objection is noted, but the jury will be instructed regarding the bail jumping.
It can't be because that's double jeopardy. Under the law, if two charges are identical in nature, you cannot place me in jeopardy of life and limb twice. You can't do that.
What's your next?
The same case number.
What's your next request, sir? I'm noting your objection.
I'm trying to talk. Can I get it out? You always want me to not interrupt you, but you always find a way to talk over me.
I understand your position. I'm saying it's overruled.
You always want respect. You always want respect, but don't want to give it. I'm charged with the same bail jumping charge here that I've already been charged with. That is double jeopardy.
And even then, double jeopardy only latches when there's been an acquittal or conviction.
You can't charge me for the
So we're not even there yet.
same exact bail jumping that I'm already charged with, that I was charged with before this even came about.
Sir, the bail jumping charges in Waukesha County are based upon your violating your bail while in Waukesha County by driving through the Christmas parade. And allegedly killing 6 people and injuring 61 others. If the bailiff could confirm...
In other words, it's not double jeopardy if he's been charged with bail jumping in Milwaukee, if the charges for bail jumping are due to Milwaukee specific charges, then it's not double jeopardy.
Do you have any requests?
First of all,
related to the jury instruction?
It's that whole jurisdiction thing you like to bring up a lot.
The question is, do you want this instruction read or modified in any way?
You just said I got a constitutional right not to testify or to testify. I didn't make either one of those decisions, so I don't understand
The
what
jury
you're asking.
instruction is typically read when a defendant does not testify. In every other case that I've had, the decision on whether to testify was a decision made by the defendant personally. In this case, the court found that you forfeited your right to testify based upon your conduct. That is the ruling I made this morning.
How did I make that decision though? I didn't.
My question to
never
you
say yes
is,
or no. I never
do
say
you
yes or
want
no.
the jury instructed that your silence must not be considered by them in any way and must not influence their verdict in any manner?
What do you mean my silence? My Fifth Amendment right?
Correct. I'm not hearing a request from you to have the jury
Because
given
I don't.
this instruction.
I don't understand why you're asking me the question, Your Honor. I never decided to or not to testify. I never
understand
decided
that,
either
sir.
way.
I understand that.
So how can I answer that? I don't understand why. I don't understand.
We are now at the moment where we are discussing whether the jury should receive an instruction specifically on you not testifying, irrespective of the reason for that. I believe I could modify this instruction to simply say a defendant's silence or a defendant not testifying should not be considered by the jury in any way and must not influence their verdict in any manner. Are you making such a request for a modified instruction?
I don't understand the question because I never decided to or not to testify.
I understand. I understand what you're saying, sir. I really do. But in light of the court's decision that you forfeited your right to testify,
How did I forfeit something I
do you
never
want the
said?
jury to be instructed something to the effect of they cannot use your silence, meaning they cannot use you not testifying against you in any way?
I don't understand because I never made a decision not to or to testify.
I'll ask you.
He doesn't fucking understand what the judge is trying to tell him, and it's infuriating on so many different levels, because it's infuriating because she's trying to help him, number one, number two, he's trying to like manipulate the process to his favor, which makes me angry that the judge is trying to do him a favor in the first place.
One more time, and if you do not answer with a yes or no, I will take your answer of not answering as you are not making a request for a modified instruction.
How can you do that,
Do
Your
you
Honor?
want this court, sir, to instruct the jury in any way regarding you not testifying in this case?
I don't understand the question.
All right, then based
I don't
upon there has
understand.
not been an express request made by Mr. Brooks to give either 315 as it's in the standard or pattern jury instruction or a modification as this court has suggested, 315 is to be taken out of the jury instructions.
How are all these decisions being made without me understanding?
Ed, Ed asks, thank you for being a member for 2 months. When the jury deliberates, how do they remember the statements they're supposed to disregard? There's too much to remember. I mean, it's hard. I mean, I can't speak to it because I've never been a member of the jury. I've had jury duty, but I've been able to get out of it. My only assumption is that the jurors are taking notes or, erasing notes, as it were, to note what they are and are not supposed to take into account when making their decision. But I can't tell you specifically.
Then I have looked over the verdict forms, and other than really what I would describe as some consistency in how phrases, whether there's all caps, not all caps, but
All caps.
what we call the sentence.
Oh, for fuck's sake. I can't believe he tried to latch on to the all caps, all caps. She's not talking about your goddamn name. She's talking about the jury instructions.
Capitalization for the charges. For example, I want to be consistent with how I spell out first degree.
In 6 minutes.
What's that?
Apparently, the judge is going to be on the bench in 6 minutes.
Okay. All right.
Intentional homicide or first degree recklessly endangering safety. There was just sometimes it was capitalized, sometimes it wasn't. So we're looking through all of that to be consistent. I want to make sure the word information is capitalized since that's the charging document, things of that nature. It is my practice, and you should be aware, Mr. Brooks, that I always put the not guilty verdicts on top when I hand all the verdict forms to the jury. And by that I mean it's by charge. So they're collated, if you will. So the not guilty followed by the guilty for counts 1 through 76.
You said it's collated. What do that mean?
So I put the not guilty, then the guilty for count 1, followed by the not guilty and the guilty for count 2, and so on and so forth, all the way through the remainder of the counts that are alleged in this case, which in this case total 76.
I don't understand. So how?
I looked at the special questions
Will you
that
answer
are
that, Your
on the
Honor?
guilty verdicts only. They did appear to be proper. Again, just some grammatical things, but I believe those are all accurate.
Can I go to the other courtroom?
state.
Since you don't have to answer any questions, but I have to answer all, can I just go to the other courtroom?
Not at this time.
Why not? I keep telling you I don't understand these proceedings, and you just keep running right over my rights, like you don't even hear me saying anything.
Attorney Basie, are you handling the verdict forms? Go ahead.
Can I go to the other courtroom, please?
Are you waiving your right to be present in this courtroom?
I'm not waiving anything.
Then the answer is no.
I'm making a request.
No.
Then how's it? So what? You gonna try to force me to interrupt and do all this so you
I'm
can
not
make the
forcing you,
record
sir. I'd
and
like
make
you
it
to be
seem like
here.
I forfeited something that I came in here as soon as we got on the record and made a request to not be present for these proceedings. But when I'm making a request to avoid the drama and all that,
Sir, the only one with the drama is you.
it's you too. You're the big contributor to the whole thing.
Mr. Brooks, I have to preside over this case. I
Yeah,
have
and
to
you haven't
make
been
determinations.
impartial or fair yet.
Mr. Brooks, I have a question to the state. I ask that you not interrupt, and then I'll turn
It's
to
not
you
about
for
me
a response.
interrupting. It's about me attempting to understand. I've been saying that since we came in here.
Mr. Brooks, I
You
will
can't force
respond
me to
as follows
understand.
to that. You waived your right to counsel.
I didn't waive my right to know.
Do you have any requests?
I ain't waive my right to shit.
Question is, do you want this instruction read or modified in any way?
You just
Sure. Before I address all of those, are there any of those final type of issues, sir, that you would want the court to address? You have been unmuted, so you can answer that. Mr. Brooks, do you have any of those final type of questions or issues that you want the court to address? You are unmuted. I am.
I just told you since nothing I say even matters at this point, I'm just gonna tell the jury what they need to know. I'm just gonna tell them the truth.
Oh.
Mr. Brooks, you are aware that your closing arguments have to be based on law and fact, correct?
They're gonna be based on whatever I'll base them on.
Oh, yeah?
Well, I trust the state will object when appropriate,
Well,
if
It's gonna
appropriate.
be a whole lot of objection then because I'm gonna tell the truth. You haven't allowed. You just been making all the decisions for me, even though you know I told you repeatedly that I don't understand, and you still make decisions based on my behalf without my consent, without me. I'm telling you I don't understand, and you still make a decision determining my life.
Are you
Whose fault
telling
is
me,
that?
sir, that you will refuse to follow the simple rules of decorum, courtesy,
It ain't
civility,
no-
the rules of evidence, and
don't try to come
the
with
rules
your
of
slick
procedure?
words. Don't try to come with your slick words, and don't put words in my mouth.
Slick words.
I am not being slick. I'm trying to
You've
preserve the integrity.
you've been slick. You've
All
been
right.
slick.
All right. I'm going to mute you, sir, since what you are saying is not productive. It is not courteous. It is disrespectful.
I don't care.
I
what
need
you
to
think.
go
I don't
over
care
these.
what you think.
All right, I'm muting him because I need to go over these important issues that have been raised by the state. So as far as the question is, do you want this instruction Sure. Before I address all of those, are there any of those final type of issues, sir?
Oh
that
God, I really hate
Mr.
picking
Brooks,
this
you have
one,
any
but
position on that? I am
it is what it
unmuting
is.
you. I would note he takes the headphones on and off throughout. He doesn't have them on. He's looking at a book.
I wish you would stop saying, look, I'm looking at the Bible. Thank you. It's not just a book, it's the book.
Can't disagree with you there, sir.
Yeah. How many people actually live by it, though? Anyway.
Sir, I'm contemplating putting an hour time limit on closing arguments.
I ain't doing no closing argument tomorrow.
The closing arguments will most likely be tomorrow.
I'm not doing it tomorrow.
Then you'll forfeit your right to give one, sir, because as we have...
You can't force me not. What type of court is this where you can say you're gonna force somebody not to be able to give a closing argument? How's that lawful
Sir,
law?
if you choose not to give one...
Oh my God, what a child.
How's that lawful law?
Sir, if you choose not to give one you're not letting me finish, and you're mocking me right now, which is incredibly disrespectful once again.
Okay,
You didn't even let me get my sentence out.
You always want to make an incorrect record. Go ahead. Make your incorrect record. Go ahead.
I'll mute him once again because clearly he just wants to be disruptive this afternoon. But as we have been talking about over the course of the last, 10, 15 minutes, talking about the timing of everything tomorrow, even though I have 107 pages of jury instructions, the first 73, I think, deal with what is read prior to closing arguments. That means the parties should be prepared to give their closing arguments tomorrow afternoon. I will do my very best with just one mid-morning break to get through all of these, the first part of the instructions. Then the state will give its closing argument. I'm giving the parties 1 hour each. I think that's reasonable under the circumstances. Whatever the state doesn't use in its initial time of closing arguments, it can reserve for rebuttal. But then following the state, we may need to take a break of some sorts, probably before the defendant goes, just for the jury's sake and the party's sake. We will need a comfort break. But you should be prepared to go tomorrow afternoon. Then the state, if they have any rebuttal, will get up within that time limit. I will myself, and I'll have my clerk make sure we accurately...
Mandy, can you check your Discord?
All right, Mr. Brooks, do you have any position on that? I am unmuting you. I would note he takes the headphones on and off throughout. He doesn't...
All right, now we're finally in... We're getting close to it.
We can get this done tomorrow. And so that's my expectation.
We're almost there.
So, Mr. Brooks, I'll unmute you, but that is the expectation of the court, that closing arguments will be done tomorrow.
You can't rush me to judgment, or you can't practice law from the bench and tell me when I can do something and when I can't.
Mr. Brooks, I actually can, under all of the rules of procedure. It is my job to make sure there's effective and efficient administration of this trial.
Then I should be allowed to, then if that's the case, then I should be allowed to tell the jury what they need to know, which is the truth. That they have the power. They have the power to nullify laws if they don't agree.
You are absolutely not allowed to tell the jury that.
All right, so I did actually hear this bit on Monday, where the moment he uttered the word nullification, the judge was like, oh, fuck no, we're not having any of that.
A jury instruction that I will have ready to go if you even attempt to raise the issue of jury nullification, sir. You have absolutely no right to raise that. That is clear under the law.
I can raise what I want to raise. And you can't, so you added these jury instructions at the last minute. Then you should have never approved them from the get-go, because I never approved them. I told you I didn't understand them at all whatsoever, and you still passed it.
Sir, if you understand jury nullification, you understand jury instructions. It's clear to me you have done your homework.
What you talking about?
True.
What you talking about? I'm going to let them know that they can nullify any law they don't agree with, which is my right.
It is not your right to do that.
Say that it's not.
It is
Show me
not
where
your
it's at.
right to raise
Show
jury
me-
nullification.
Show me lawful law then.
Lawful law.
Show me.
All right, I'm going to mute him once again. He's starting to raise his voice. He's starting to hit his hands on the table. It's very clear to this court that it's going to be a challenge tomorrow during his closing arguments. He does not have an unfettered right to say whatever he wants or how he wants. If he is going to be adamant.
I honestly don't know what his theory was, Tones. I mean, it is basically like a last gasp. Usually jury nullification is a last gasp when you know the evidence is overwhelming and you're desperate for an out.
About defying the court's rules, which I will tell him in part what they are. Oh, I need my court reporter. I'll wait for her.
This is back live. We're back live.
Thank you. All right, it's 7:05. We're back on the record. I wanted to advise the parties that earlier today I received information from the clerk of court that she had received an email that the person sending the email had found a post on Justice for Darrell on Reddit, so it's a subreddit.
What?
I'm not familiar with how Reddit works.
Oh my God!
And that the thread on the Justice for Darrell Reddit site was claiming to be a member of the jury pool.
What?
And I am going to provide the parties with the information that I was given this morning. It's a color copy of the attachment and the email that was sent. The email was received by the clerk of court at 9:10 a.m. Then my clerk received a notification at 9:30 a.m. that the clerk of court wanted to speak with me. You may recall this morning I stepped off the bench for a little bit of time. I read through the information that was provided to me, which was an email, and then the attachment, which is a color print off. Looks like the person took a screenshot, and that the anonymous post claimed to be a member of the jury on the case, and here are my thoughts on the trial and on this subreddit. And apparently, again, it's a subreddit called Justice for Darrell. All those, Justice, the number 4, and Darrell, all, no spaces. I then had contact with Captain Dussault, advised him that this should be investigated, and basically turned over the matter to law enforcement for a full investigation. At this point, or at that point, I made a determination based upon my review of the information that I would not stop what was happening in terms of the trial with the instructions to the jury and ultimately the closing arguments, and then turning the case over to the jury for deliberations. And of course, I am concerned about the integrity of these proceedings, and I will take whatever action that I deem appropriate once a full investigation is done. But at this point, there is no, I would say, credible information that this is in fact a member of the jury.
Okay, thank God. All right.
But I will leave that for law enforcement to determine. Of course, if need be, at the conclusion of the case, when the jury reaches a verdict, I certainly will consider whether...
You mean everybody knows damn well it's a bullshit account.
...is warranted. So that's the information I
The
wanted
judge
to
is simply
provide.
covering all bases.
Copies of this information will be provided to the parties, and there is a full investigation underway by the Sheriff's Department. I have no further information about it at this time. I will not be the judge that will further be reviewing it in terms of any requests related to that investigation. I will simply be handling whether any requests as it relates to this case in particular. And I hope we have the copies for the parties. And we'll provide those. Go ahead.
I'm making sure you was
Go ahead.
first. What is this?
Does this motherfucker even know what Reddit is?
Tell you, sir, is that there.
I doubt he knows what Reddit is.
On a site, or maybe it's an application. I'm not entirely sure. Called Reddit. There's a subreddit.
Oh my God.
That is entitled "Justice for Daryl," and it was on that subreddit. That
Okay.
Someone wrote an anonymous post claiming to be one of the jurors. That, of course, would be a violation of the rules that I set up for the jurors.
If this was true, it would be an immediate mistrial.
To law enforcement, so they could make a full and complete investigation.
Or close to it.
I accept for value in return for value these documents. I'm confused.
He doesn't know what Reddit is.
At this point, sir, I'm providing.
This is the one thing where I'm actually I think he's being genuinely confused about. I honestly doubt he knows what the fuck Reddit is.
The information. I trust.
I don't know.
Review it, and if a party believes that any request needs to be made of this court, then an appropriate request will be made. But at this point, I'm just advising the parties of the information that I have. And I will add this. I will, of course, it's important that the results of any investigation be turned over to the parties. I don't know how long that will take, but that is also my direction. That was really the only direction I gave to law enforcement, is that the results of the investigation that be turned over to the parties.
He also said he didn't understand the jury instructions, so that's fair.
Was this just found out about this morning?
Yes, the email that was sent to the clerk of court was received at 9:10 a.m. And then that email and the attachment, I'm aware of a second, I will say I'm aware of a second email that was sent to our clerk of court at 10:02 a.m. And in
fairness, I did not know Justice for Daryl existed as a subreddit until today, which is kind of, I mean, it's honestly par for the course for trolls on the internet that there would be a bunch of fucking idiots who would pretend to be on Daryl's side. But yeah, I had no idea this subreddit existed until today.
I think when we stepped off the bench following the case being given to the jury, I was advised that other emails had been received throughout the court system, and I simply said, obviously,
thank you, Poe, for the $2 super chat.
Law enforcement, I haven't seen it.
And thank you, Akira, for the $1.99.
But any person who works in the clerk of court's office who has received an email that email about this topic will be forwarded to the sheriff's department. Their forensic unit is handling the investigation, to my understanding. Attorney Upper, did you have a question or something to state?
Yes, Your Honor, I just wanted to state for the record that I have also received similar emails at my office this afternoon. They were sent not to me directly, but to the district attorney's office website. And I only wanted to point out that in viewing the contents of the posting, well, first of all the emails refer to the exact same posting, and the language is the exact same in all the postings. In viewing the content of the posting, we question the veracity of the posting because it refers to things that, quite frankly, are not true. And also, upon reviewing it, Your Honor, we came to the conclusion that it does not exhibit any material prejudice against Daryl Brooks that may affect the veracity of any verdict that may be returned in this case. The posting is largely critical of the court and to some extent the prosecution, but the nature of the posting is actually in support of Mr. Brooks. That's
it is. That's the one thing too. So it may not really be.
There's any reasonable reading of.
It really depends on a lot of different circumstances.
To believe that it suggests the juror harbors substantial or material prejudice against the defendant.
Thank you. I appreciate the additional record.
Can I say something, Your Honor?
Go ahead.
Just briefly skimming through it. I do want to state for the record that I have no involvement with this. I'm really like shocked like this even came to light. I will say just by skimming through it, these are definitely things that have been talked about in the court. So common sense would say that this came from someone that has either been in the court to hear what goes on in the court or
Okay, I gotta go back. Maybe it may very well be a fucking act for him.
Record.
Can I say something, Your Honor?
Go ahead.
Just briefly skimming through it. I do want to state for the record that I have no involvement with this. I'm really like shocked like this even came to light. I will say just by skimming through it, these are definitely things that have been talked about in the court. So common sense would say that this came from someone that has either been in the court to hear what goes on in the court or a jury member. This is no other way.
Well, actually, the proceedings are live streamed worldwide, Your Honor, available on YouTube worldwide, so I don't agree with that assessment.
Well, it's pretty obvious that this would come from somebody who's actually...
Yeah, I'm wrong. This might actually be a fucking ploy by him. I think I am wrong.
I'm leaving it in the hands of law enforcement to do a full and complete investigation. Again, I take the integrity of this process incredibly seriously. And if there were to be a juror who violated the rules, I would take that very seriously, and I will not hesitate to take any action that I deem appropriate. At this time, it is simply being investigated. This was an anonymous post, and if either party believes any further action needs to take place as it relates to this particular jury, then I trust they'll file the appropriate request with the court. So with that, the courtroom, go ahead, I'm sorry. Something else, Attorney Amber?
A different topic, Your Honor,
Oh,
if
sure,
possible.
go ahead.
While we're all together, I just wanted to address exhibits and what the court's procedure would be. We have no objection to any exhibits going back to the jury room if they are asked for, and precluding the requirement that we all assemble every time a note comes out asking for one exhibit. So as long as we're all here and we have some time, maybe we could discuss that.
I'm willing to discuss that. Do you have any position on that, sir?
Yeah, I would object from the standpoint that I would need to see any exhibit that's being asked about and the relevancy of.
When was this alleged post made? Was it made today or over the weekend or what?
That exhibit being asked for. I think that's only fair.
Exhibits that have been received, a relevance objection would no longer be valid because the court has already ruled on it.
It was today, this morning?
The admission of the exhibits. The issue is whether it goes back to the jury room. I'll give you for example. Sometimes in a trial there are medical records that need to be filed in their complete form under the statute, but really maybe only a portion of it would go back to the...
So bear in mind, I would note that he has already admitted that he has access to the internet because he's already talked about in his opening statement that he saw the mean comments on YouTube and mean comments on the internet about him. So he does have access to the internet at the very least, or the wider internet, not just simply access to the legal databases that are available.
the jury, or depending on why they were offered and whether there was any medical testimony regarding a diagnosis, for example, could impact that. Sometimes there's privacy issues with an exhibit, if there's a social security number for a witness or something like that. But generally speaking, the exhibits have been received, and the jurors can ask to view photographs, written documents. They can even ask to view the videos. The videos would need to be done one of two ways, either which requires everyone to assemble, because we do have the technology to play them directly to the jury room, but that simultaneous with that is it would be played in here. So everyone would be seeing what's being played in the jury room at the same time, so that does require the parties to be in court. That allows the jury to continue with their deliberations, talk about what they're seeing, etc.
So can the jury see in here now?
No, I'm talking about a video. We have the ability to play it directly. There's a TV. I should have said that. Probably not too, why would you know there's a TV in the jury room, right? So there's a TV monitor in the jury room that is connected to the technology in the courtroom. So whatever is playing here could be a still photograph, could be a document, could be a video. We can play in the jury room at the same time.
It was verified by a mod of the subreddit. Okay.
So it would be only the exhibits that's been
received.
So
Correct.
nothing new. Nothing's gonna come out of the blue and be like, yo, yeah, we're gonna.
Only what's been received during the trial. If it would be helpful, I can have Madam Clerk give you the printout of the exhibit list that shows everything that's been received, if you would like.
That's about like 7,500.
There's a lot of exhibits.
Murder trial. Ha ha
I
ha.
think it'd be helpful just in case.
Fucker.
I'm guessing at some point that will come into play.
Right. For example, they may come back and say, we'd like to see Exhibit 15, which is the map, the large map of the parade route, okay? They might want to see the other map. Maybe they want to look at a video.
Reddit never ever
A lot of
lies.
exhibits, so I'm not going to speculate what they want. Sometimes they write notes to us and say they literally list out all the exhibits that they want. Other times they'll say, can we have all the exhibits? So sometimes parties do stipulate. That's what the state, I think, was trying to get at. So do you have a position on that? If the jury requests an exhibit, do you want the court to rule on it individually, or do you agree that if they request an exhibit, it can be released to them?
A rule on it.
All right, fair enough. Anything else, Attorney Opper?
Yes, we had discussed yesterday, and I'm not trying to get too far ahead of myself here, but what was the time limit that the court wanted to work off of for giving notice to the parties when the verdict is available?
30 to 60 minutes.
Okay. Thank you.
Some of that will depend on when it is, if it's late in the evening versus during the day. And you might be wondering, how late will I let exhibits? 15, 5, and 55. Number 11 is the fourth person.
You said 15, 5, and
55. So I can pull.
I was gonna say I don't know. I know 15.
15 is the map.
15 is the map. Yeah.
Any objection to the map, sir?
Yeah. I want you to rule on everything.
Well, I was going to go one by one. So I'll start with exhibit.
Thank you, Z360, for the $2 super chat.
What's your position on that, sir?
My position is
These nuts.
The relevancy of the map. I think it's been seen a million times. I know it by heart now. That's probably the only one I know by heart.
The fact that the fact that the map has been seen multiple times does not change whether or not it's still relevant to the trial. You fucking idiot.
Well, what's the state's position?
Yes, we absolutely, there's no reason not to send that back there, Your Honor. There's 76 counts that they need to work through, and to assist them in identifying which victim is which and which group they were with and where they were on the road. Absolutely, there's no reason to hide that from them. It's helpful to them in their deliberation.
All right, I will send Exhibit
Kisker
15.
Venrath says, Artie, the subreddit is either by him or someone close. It's literally subject matter jurisdiction and the judge is biased as points. Interesting.
Back to the jury room. It is an exhibit. And there really is no reason not to send it back that has been identified by the parties. All right, the next exhibit is Exhibit 5. That is the photograph of Erica Patterson.
Oh, I definitely object to that. Seeing as how it was supposedly 2 incidents, one of which didn't even happen, which the prosecution sent paperwork to acknowledge that it never happened. So I don't even. It's too dicey with that. What incident would 5 be referring to? One of which
The
never
battery
happened,
count.
and then one. I don't even know what I'm looking at if I look at 5.
What's the state's position on 5?
Again, Judge, there's no legal basis to exclude that from the jury. There's nothing prejudicial. It's a single photograph. I should say overly prejudicial. It's a single photograph of a single person showing the injuries that are alleged to be associated with count 77. It's directly relevant to their deliberations.
There is no count 77.
Count 76. You are correct. It is count 76, not 77.
See why I'm confused?
Well, there is an amended information, and I clearly instructed the jury on 76 counts. Be that as it may, I'll find that it is proper for Exhibit 5 to go back to the jury, and that will be sent to them. Now, Exhibit 55 is a video. How long is that video?
15 seconds.
So my inclination, and I'll hear from the parties first, and then I'll give you my inclination. So any objection to playing for the jury Exhibit 55?
What exactly is in Exhibit 55? I don't.
It's a video from Curry Insurance facing eastbound showing the grannies being struck.
Oh, God.
We could put it up if you want to preview it, Your Honor.
Go ahead.
And we are requesting that it be viewed by the jury in their deliberation room.
What I can tell you, if I do allow it, since I would have to we'll verify that the technology is working, and then I would play it for them twice through. And we would watch it at the same time as they're viewing it. Theirs would just be in the jury room. But I'll preview it for Mr. Brooks so he can see it first. Well, the state will preview it for me.
Right now, California, as they're talking about this right now, the jury is in the middle of deliberations.
Your response, sir?
Let me guess, he's going to object.
Yeah, I don't object to it. Trying to keep this in order. I guess my objection would be
Why?
Well, it would be hard to say why the jury would request it.
If the jury, in fact, let me put it this way: if the jury, in fact, requested this video, it's entirely possible that they want to make sure that all the names of the people who are listed as injured were in fact identified in the video. That would be my summation, is that they're trying to ensure that they're able to find guilty for each and every one of the people that he committed the reckless endangering of safety by going back to these videos and ensuring that all the identified parties have been named.
I'll just let you rule on it. I don't particularly.
Allegedly.
There's so many videos that's kind of like the same video anyway.
Well, Exhibit 55 was received by the court. It's relevant to the charges in this case, and I will show it to the jury. I will work with Teresa and then the jury bailiff to ensure that the technology is working when it's up and running. I will play that for them twice through. This is what I have proposed to write on the note back to the jury as it relates to all three. Exhibits 15 and 5 are attached. Exhibit 55 will be played for the jury 2 times, hyphen the clip is 15 seconds. And then I will initial that and date it.
Any reason why it would need to be played twice?
And I just would note that the jury foreperson wrote yesterday's date. It is the 25th. My date will be indicated. Obviously, they didn't get the case until today, so it's just a Scrivener's error on their part, putting the 24th versus the 25th. They don't have their technology with them, so I can't really fault them for that. All right.
Any reason why it need to be played twice?
That's my practice, at least on short video clips.
So what about if they request for a long video?
Then I'll make a determination then. I find that since we have the new technology, it's easier just to do that and play it twice than to bring them out and for them to say stop, and then can you go back and can we watch it again, because that's my experience. So I'm really trying to avoid that.
Real quick, Kit one, sorry I missed this, Kit. $5. Wouldn't going to the other courtroom negate any appeal based on lack of access or whatever it would be called to be physically present? Well, that's basically the idea of why the judge put him in the other room with video camera access to the jury and audio access to the jury. That way, he's still able to interact, but the judge has the ability to mute him should he decide to get belligerent. I think, honestly, there's no way an appeals court would strike that down as being unfair to him, because she's giving him all the opportunity in the world to still participate, but the judge still has the ability to rein him in with that magical mute button. Paul, $10. Thank you. What are the chances to come back with a verdict tonight? Honestly, I don't know. If I'm still beholden to the 1 to 2 hours. So if that happens, which would be what? 10 o'clock would be the limitation, 10 o'clock our time. We could very well see a verdict.
So we'll stay out here, and then we'll work to, they'll have to pause their deliberations so we can interrupt them and give them the exhibits, and then make sure the technology is working. So if the state wants to have that ready to go.
I set for value and return for value these documents, Your Honor.
Thank you.
Okay. Guys, I will still be on for as long as the jury is on. If they have a verdict, I'm still gonna be going through it. I'll let me at least make that promise.
Is there audio with this, or is it just video? Okay, thank you.
Shut up, Jennifer. Trying to hedge my bets here. Hey, Mandy, can you change the stream title to Verdict Watch, or at least the beginning to Verdict Watch, but leave everything else the same? So Verdict Watch, Waukesha trial, day 14, etc. Or day 14. Why did I say 17? All right, we're behind, so I'm gonna.
All right, the video was played twice. We'll wait and see if they have any other questions.
Your Honor.
Yes, sir.
About this Reddit, is that how you say it, Reddit?
That's my understanding.
Okay.
This particular person is who the email was sent from, the person at the top of the page?
Do you have the email that has the 9:10 a.m.? That's my understanding, yes.
Alleged Reddit?
Were they identified to have any connection with the trial in any way?
I'm leaving the entire investigation in the hands of the Sheriff's Department. I can't answer that. I'm sure they're looking into it, though, because that's a good question.
Subject for the matter jurisdiction.
Do you know if there are any additional?
Oh my God.
Subject matter jurisdiction, Your Honor.
Oh my God! Shut the fuck up.
Will we be addressing it for the record?
I wouldn't go too far because it sounds like it wants to be.
He just had to fucking throw that bit out. All right, we're gonna go back to. We're gonna go back to Monday, where he says, where he claims he's gonna tell the jury whatever he wants.
We are today, and I will work on that as we break and have a very clear advisement for him tomorrow morning. He may run the risk of being put in the other courtroom because he'll forfeit by his conduct his right to be present here, and I will be able then to exercise the mute function. I have to balance, frankly, the fact that he's in custody, that it takes time for this jury to be excused. They have to walk an entire hallway behind me. I frankly don't want him to look worse than what he's looked, frankly, in front of this court when they haven't been in this courtroom. I need to preserve how he looks to this jury. And I will need a very clear pledge by him that he will follow the rulings that I make as it relates to the closing arguments. He cannot raise jury nullification. He cannot raise facts that are not part of the record. He cannot raise subject matter jurisdiction. He needs to argue the facts based upon his theory, based upon the evidence that's been presented, and those are the bounds. If he's going to, I can only imagine there may be some of
different speeds. Was that in the question?
They just said, can we see Exhibit 55 at 40% speed? Obviously, I don't recall specifically if this video was shown at a reduced speed, but many of the videos were shown at reduced speed during the trial. That was allowed. I think it's proper to also show a video clip to the jurors if they request it at reduced speed. So I'll grant the request.
What would be the significance?
The significance is the jury's requesting it, sir.
I'm saying at that speed.
That's their request. I can't tell you the significance for them. I don't want to speculate, but I think it's proper given the technology that we have available and what was done during the trial. So I will allow it.
I would say.
Why even ask me if I have a position?
Because that's what I'm required to do, sir.
But you're not required to address subject matter jurisdiction, which hasn't been proven for the record.
Oh, shut the fuck up.
Not allowed to answer any questions I ask. From your name.
Mr. Brooks, I'm not going to relitigate your case right now. And I've made my decision on subject matter jurisdiction, so your request that I address it once again is denied.
Of course it's denied. Of course, because you can't prove it on record.
Oh my fucking God.
It has to be proven. It has to be proven at some point. Or do I gotta go through the song and dance to get it proved?
This really is just a game to him, and like this whole nonchalant act is just more and more infuriating. But
just once.
But what I was going to say is the fact that the jury is asking for certain video to be played at a 40% speed tells me that they are actually taking this seriously. In other words, the jury is not going in there throwing it. We all think he's guilty, right? Guilty, guilty. The jury is actually ensuring that the prosecution got every proved beyond a reasonable doubt every count. So my guess, my speculation, the reason why they are asking for reduced speed is to look at the video specifically to see the individual people who were injured or possibly not injured who were included in the counts charged. So it may very well be that they could result in a not guilty plea for one or more of the 60+ charges of recklessly endangering safety. That's my speculation. I don't know if they're actually going to do that, but I'm saying that the fact that they're asking for a reduced speed means to me that they're actually taking this seriously. Well, I know.
That's 40% speed? Yay, nay.
I mean, for all I know, the 6 murder charges could be part of this reduced speed video. I don't know. It depends on what Exhibit 55 shows.
The video clip is now ended with the state just confirmed the speed at which it was just played.
Yes, 40%, Your Honor.
Thank you.
Okay, that's right. Danny reminded me. It's showing the grannies, the dancing grannies being hit. So I think at least one or several deaths were probably showcased in that video. So that actually could also go towards whether or not they're looking at whether or not he intentionally killed the grannies who were struck. So that could actually also go into the jury's deliberations.
Right, and if there's another question, the court's going to step off. Obviously, will remain open.
All right, I just refreshed to make sure I'm live.
Objections by the state. If there is an objection, I expect that he will stop and wait for this court to rule on the objection. I expect that if I sustain an objection, that he will honor it. And if he can't pledge to follow these very simple rules of courtesy and decorum that are consistent with the rules of procedure and the rules of evidence, then he will be in that other courtroom for his closing argument, so that I can exercise mute, frankly, to protect how he looks to that jury. Because that is the balancing that I am tasked with tomorrow, is to ensure that this jury makes a determination based upon the evidence and the law. All right, Mr. Brooks, do you have any position on
All right.
changes? We can get this done tomorrow.
Hold on. I think this is okay. This is from today. Now we're on Monday morning.
When you tell me this is what you need to do, I'm going to take it by what you're telling me that I need to do. If I needed to make anything request-wise or anything that I needed to present to the court, it has to be in writing. You told me to do that. I did it. You also brought up when I asked numerous times before when would I have a chance to present things into evidence. You told me we were not at the evidentiary phase of the trial yet. So I took that as saying, okay, well, at some point I will have the opportunity to place things into evidence that need to be put in evidence for the record. So I'm not understanding how a decision can be made for me to actually forfeit being able to put things into the record that need to be placed into the record. All these things are things that, quite frankly, allow me to put on a defense. Things that need to be known, things that should be in the record, as far as filings, as far as ICFs that I was told to by you to address certain ICFs either to you or to the clerk of courts, which I did, and received copies for all of them except until last week. It was a few of them that I didn't receive copies for that I'm still wondering why I haven't received those copies when I received the copies of all the ones before that. But in terms of that, I did what Your Honor asked me to do. And these are things that were part of my defense that needed to be placed into the record. So where my confusion comes in is not being able to place those things into the record. Things
Mr. Brooks,
that clearly help my defense.
I stand by my ruling. I'm not revisiting it. To the extent that you claim lack of understanding or your lack of consent, it's been made abundantly clear on this record your position on that. I'm not revisiting it. I'm further advising you that when this jury comes out, I expect that you will honor the decisions that were made, not agree, but you will honor them and not interrupt the court or these proceedings as I instruct the jury.
So how am I supposed to put these things in the record that need to be in the record?
Mr. Brooks, I'm well aware of the effect my ruling had, and I'm not going to debate it with you further.
I just want to know, how am I supposed to get these things on the record? How am I supposed to, because the filings that I gave, you actually filed and gave me the copies back. So are those in the record?
Mr. Brooks.
Okay, so this is one of those examples where this motherfucker doesn't understand that the fact that filings are placed, or that the fact that he put things or filed motions or filed affidavits or filed whatever the fuck, The fact that they're in the case file does not mean they're entered into actual fucking evidence. He doesn't understand that. And so the judge is going to try and explain it to him, but he doesn't fucking get that at all. So no, your soft-sit bullshit affidavits are not going to be presented to the jury as evidence because they're not being presented as evidence.
I'm just seeking to understand. I'm just seeking to understand.
Mr. Brooks, I cannot explain procedure or evidence
The filings that
or
I
the
filed.
rulings or
I'm
the
asking
law
a question,
to
Your Honor.
you.
I'm merely asking a question. The filings that I presented to Your Honor.
Any filings
For
with
the
this
court.
court are in the court record. That does not mean they're evidence, sir. And I told you
That's
that
not what I'm
previously.
asking. I'm asking, are the filings part of the record? The filings that were filed and timestamped, that were notarized.
Doesn't matter if they're
To the
notarized.
court. All the filings. The appearance bonds, the statement of particulars, the notice of special appearance, the court docket sheet, your oath of office, everything that I tried to present into the record. How am I not able to make them part of the record?
Sir, they were filed because you presented them to the court during the course of this case. Anything that was not offered as an exhibit and received during the evidentiary phase is not evidence in this trial.
That's what I attempted to do, and you told me that I couldn't. You told me,
Mr. Brooks, I am bringing this jury
Your Honor,
out.
with
Listen
all
to me.
respect, you told me that we were not at the evidence when I said I
Thank you,
had
Terry. I appreciate that.
exhibits as well. I have stuff that I want to put into the record. I even asked, I said,
Mr.
may I
Brooks,
give an offer into evidence?
I'm
these-
going to stop
these
you
things?
once again. I'm not going to have this discussion and debate. The evidentiary phase of this trial is closed.
It should not be, though, Your Honor.
I understand your lack of consent. Your
So
objection
when would I
is
be able to
noted
put?
for the
When
record.
would I be able to put vital information into the record, which I haven't had the opportunity to
That
do?
opportunity has closed for you, sir.
So
He fucked up, and she closed it for him.
you saying basically you're prejudicing my defense
No.
by me not being able to present.
No, your conduct this morning. No, yesterday. I'm sorry. Yesterday, your conduct prejudiced your ability to, or forfeited your right to present any additional evidence.
Things
When you refused to talk to her about your ability to, about whether or not you wish to testify on your own behalf.
into evidence, offer into evidence, filings and important paperwork and documents.
Mr. Brooks, and you
How am I
forfeited
not-
your right to do that by your conduct yesterday, and I stand behind that decision.
I
I'm going
asked
to do the
before
following,
yesterday,
sir.
Your Honor.
I'm
I
going to
asked
do the
this
following.
before yesterday.
You have not honored my request to you that you cease debating me on prior rulings
I'm not trying
of
to
the
debate.
court.
I'm trying to understand why my due process is being violated.
Mr. Brooks, the record speaks for itself.
No, the record
I am
does
going
not.
to take
It
a
does not.
5-minute recess. When I come back out, the jury will also be coming out. I'm advising you there will be no multiple opportunities where I give you to conform your conduct to the rules of decorum
Well,
and
then
courtesy.
just hold me in contempt, then, Your Honor.
You are
Hold me in
hereby
contempt because
advised
I didn't even. I'm trying to
that if
seek
you
to understand.
Start talking about
Please hold me in contempt and delay the proceedings. Please hold me in contempt.
subject matter jurisdiction or any of these other
It
issues,
needs to be addressed,
or
Your
in
Honor.
any way
We're not talking
interrupt
about subject matter
the
jurisdiction. We're
reading
talking
of the jury
about
instructions.
why my due process
I
has
will
been violated.
excuse the jury and you will be removed
Your
to
Honor,
the other courtroom.
We're talking about the 14th Amendment,
Right.
Section
I am
1.
taking a 5-minute break. We are in
Your Honor,
recess.
Daryl Brooks ejected mere minutes after being let back in the courtroom.
To reflect, we are all back in this courtroom.
Before the jury's brought out, can we address subject matter jurisdiction, Your Honor? Before
Absolutely
the jury's
not.
brought out,
Absolutely not.
is that a tacit agreement that you don't have to answer those questions as a public
Oh
servant?
yeah, this is the part where he knows how to pronounce tacit.
So are you going to act in dishonor?
Mr. Brooks,
Are you going to act
I've
in
already
dishonor?
addressed your requests.
It hasn't been proven for the record, Your Honor. It
The
should
jury
be.
is on its way,
They're not out yet, though.
but they're on the way.
You held me in contempt.
I'm not
You held me in
addressing these
contempt
matters,
before-
sir.
Have I acted in dishonor, Your Honor? You held me in contempt without me being in dishonor? How have I dishonored the court? Have I acted in dishonor? Have I rose my voice or argued with Your Honor? Have I disrupted the
Mr.
courtroom
Brooks,
in
you're
any way?
back in this courtroom at your request. The jury is coming
I
up.
never should have
Please
been.
be respectful of their time.
I
of this
have
process
been. They weren't even
and the
out
dignity
before.
of the proceedings.
They weren't even out before when I was trying to address what needed to be
Mr.
addressed
Brooks,
before they came out.
You're
Have I?
just
Am I
attempting
acting
to
in
disrupt
dishonor?
the proceedings.
Am I acting in dishonor? So that's a tacit
All
agreement
rise
that you
for the
don't.
jury, please.
It's a tacit agreement that you don't have to answer questions as a public servant, right?
All right, the jury.
No
is
jury's
not
out.
Mr. Brooks.
No jury's
go to the
out.
door.
I was trying to
Mr.
address
Brooks,
this
they
before
are
they
right
came out.
outside this door. I am not going to do this with you this morning. You either
I'm not
abide by
doing-
these rules
Am I
and
acting in
stay
dishonor?
quiet,
Am
or
I
you will
acting
be
in
in the other
dishonor?
courtroom.
Am I acting in dishonor?
Yes.
Thank you, Terry, for the 420 super chat.
Disobeying the direct order of this court to respect the decorum and the dignity of these proceedings. You are merely attempting to delay.
I don't care what you think. That's not accurate.
Mr. Brooks, I am having this jury out.
And-
if you
and you're
say
making-
one word when that door opens,
You're making a tacit agreement.
then you will forfeit your right to be present.
So you're acting in dishonor, then, Your Honor.
All right, the jury may come in.
You're acting in dishonor by making a tacit agreement that you don't have to answer any questions as a public servant. You're not holding up to your oath to protect the
All right, the
Constitution.
door is open and he's talking.
Okay, so you're gonna hold me in
All right,
contempt?
the jury cannot come in. Never mind.
Are you gonna hold me in contempt?
Mr. Brooks is.
He's out. Jesus. Terry, thank you for the 420 tip. Tom Castro, thank you for the $2 super chat. I missed that one, sorry. Think she'll enjoy sentencing this clown. I really hope that she's able to let loose a bit during sentencing. I really hope she gets that, at least that bit of satisfaction during sentencing. And Carl B, $5. I don't think it'll take about an hour just to fill out the paperwork. That's fair. Danny just forwarded me the Reddit post, and I'll try to read it out when we get through the rest of the clips today.
Mr. Brooks, I don't know what you have planned for your closing argument. So
I'm making a request, the same request. May I be able to put up
well, I guess it
exhibits?
depends on what it is, sir. So I'm not going to take up any more time because what I intend to do is once the state goes through its closing, I may take just a short comfort break depending on how long it is. And if there's something in particular, what are you will need to tell me what it is. As long as it's an exhibit from this case, then I wouldn't have an issue with it.
They would be from this case, obviously. It's just not nothing that the state had.
I'm not aware of exhibits that the state wouldn't have, that you would have. Everything that's been received, we have a list. So if it's not something that was received during this trial as an exhibit by the court, unless you tell me what it is so that I can make a ruling, I can't see how it would be relevant or appropriate for your closing argument.
They're part of my filings that you
At
filed.
747, the filings have no relevance to the issues that are before the jury. The closing argument provided a question through the bailiff. We request exhibits 3 and 4. Exhibits 3 and 4 are videos. They are the videos from White Rock, I believe elementary school, door 1 and door 2.
Yes, correct. She's back on the screen.
How long are each?
Yeah. Oh, I'm sorry, Mandy. I completely forgot to share
Exhibit 3.
what I'm
is
seeing. I
4
apologize. Give me 1
minutes
second.
and 14 seconds. And Exhibit 4
6 minutes or something?
is 6 minutes and 58 seconds.
7 minutes.
Okay.
There we go. You see it now? All right, perfect.
My inclination would be to play each one time, since they're a little bit longer, and play them one after the other. From the state?
Agreed.
From the defense?
Objection.
Noted for the record. Any specific reason, sir?
Thank you, Goober Opinion, for the 499 super chat. I appreciate it. If they gone all the way to the DV,
the
I mean-
significance of both videos.
Their evidence, sir? And the jury.
That might suggest they've gone through a lot of the other charges already.
We'll be playing them for them. We'll do Exhibit 3 first, and then Exhibit 4 shortly thereafter.
Will you be addressing subject matter jurisdiction on the record?
No, because fuck you.
No, I will not.
Is that a judicial determination, Your Honor?
Can you say what started at 3?
I can't. Oh, you're not asking me.
Is that a tacit agreement, Your Honor?
All right, they are ready.
The arrow in the middle of it.
Oh, we can get rid of that clear annotation.
Is that a tacit agreement, Your Honor?
No, it's not a tacit agreement.
Exhibit 3 in its entirety. Here you go.
Okay, so this is the DV incident.
You got, you made, you had that one, right?
Yeah, I grabbed it.
You can stop that one. They're asking it to be stopped. Any objection from the state,
No,
from the defense?
No.
Okay.
Oh no. Oh god,
All right.
guys, I don't want to say anything, but I'm on my I'm at the edge of my seat right now. Hold on. Certain folks are watching that I gotta clean up my act. So Mandy, get it. Make sure you get on me. They may or may not be my parents. Yes. Yes, I have parents. I'm not that old. I'm gonna beg them to ignore chat.
They're finished with that one. Any objection to stopping that video?
No.
All right, Mr. Brooks.
No.
All right, it'll be stopped.
Judge, for the record, this one was stopped at 1:38. Do you know what time we stopped it on Exhibit 3?
35 seconds, I think.
Thank you.
Sure.
Thank you, Madam Clerk. All right, I would think you might want to stay close by.
Oh yeah, I think that even the judge realizes that the verdict is coming close. With that statement right there. If you let's repeat that.
I would think you might want to stay close by.
Yep.
Was that a good way to reach the state?
I'm not sure
Yeah.
you did, but.
like I said, if they had gone through the first videos, if the first videos showcase the hits and potential acts that would account for the murder charges as well as the reckless endangerment charges. So if I can't recall how the judge listed the charges in order, assuming that the jury's going through all the charges in order. If the charges are going, from there to there and then to the battery, if the battery's after all those two charges, that means that they're going through this thing really fast and we might be actually close to a verdict. So, all right, let's go back to a clip from this morning.
Arguments are to direct the jury so that they have your arguments so that when they go back to determine the issues in this case, which are related to whether you're guilty or not guilty of the 76 charges, things like subject matter jurisdiction or like that would not be something that would be proper before this jury. Those are legal issues that the court would decide. The jury is the judge of the facts. The court is the judge of the law. That's why.
I'm persnickety. Thank you for the $9.99 super chat. Chat is saying no death penalty is speeding up the process. Isn't death penalty phase usually after the jury verdict's not determined at the same time? Correct. In any case where there's a death penalty situation, which this one is not, it's always separate. It's always a separate determination from the actual guilt or innocence.
I have all of these jury instructions to give to the jury.
I'm not referring to subject matter jurisdiction.
What are you referring to then? Be very specific so I can make a finding and ruling.
I was specific. My other filings that
That's
was
not
filed.
specific enough, sir. What are you referring
court
to?
docket
Which
sheet,
filing?
Let me know when you're done, Your Honor.
Which filing, sir? Not just tomorrow. So I said they should assemble. We'll get the alternates because they're sequestered.
Wait, what'd you say?
Be done. Advise that the jury would like to be done for the evening and come back tomorrow. So I said they should assemble. We'll get the alternates because they're sequestered.
Oh, darn it. Okay, that sound like the jurors are calling it a night. So we will probably get a verdict tomorrow morning.
A break for the day. I need to basically tell them that because they're breaking for the day, they should not continue their deliberations while sequestered until they're back in the jury room. So I'll read a modified kind of version of instruction 50. We are in the record.
Subject matter jurisdiction.
I decline to address that further, sir.
Will it be proven for the record?
Sir, my earlier decision, I stand behind it, my written decision.
Your written decision that's not based in any law or fact?
Hold on.
Guys, the volume is at max. And nobody's speaking right now. So, settle.
Can you see them coming? I think they're assembling the other alternates. They're in a different place. So you have to get every.
Yes.
We do need them to give the instructions.
Yes.
I thought it was 2 people that got excused from the jury.
3. There were 15.
No, I'm saying I thought it was 2 from the 16.
No, only 1.
Well, you did say 2. You said one had got excused before, and then another one was getting excused.
No, I only excused 1. We've had 15 since the first juror was excused.
Thank you, Taylor, for the $9.99 super chat.
One that had the COVID scare. What happened with that?
Mr. Brooks, I addressed all of that on the record. I'm not rehashing that now.
No need to get in your feelings. It's been a long day. I'm tired too.
Oh my God.
I would agree. But I'm not, I just letting you know I'm not going to rehash that stuff.
I just thought you said 2. You said
Jake,
2 on the record.
they chose 3 alternates with the raffle. Ultimately 12 will be the ones to decide, but there's going to be 3 who will be there just in case something happens that one of the decided 12 is unable to continue on. There is no verdict yet. It sounds like they are going to retire for the night and begin anew tomorrow. Jen, they did begin deliberating tonight.
Thank you, everyone. Please be seated. The record to reflect, I have the 12 jurors who have been deliberating, plus the 3 alternates who were sequestered in a different jury room. I want to give you kind of a modified instruction from the one that you've heard many, many times throughout this trial. Of course, for the 12 who have already started to deliberate, do not deliberate unless you're in the jury deliberation room. And that will mean from when you are discharged here tonight until you come back tomorrow in the jury deliberation room. Do not discuss this case among yourselves or with anyone else until you are deliberating in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging or social networking sites to send or receive any information about this case or your experience as a juror. I realize you are sequestered. We've taken away all of those things, but I'm just going to keep reading through this. If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them. For their part, the parties, lawyers, interpreters, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media.
Do not post to Reddit. Yeah, good idea.
Materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics, applications, or tools with communication capabilities to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so despite your telling them not to, you should report that to me. I know you're not going home. You're going to another location, but do not discuss this case among yourselves with any other juror until you are back in the jury deliberation room tomorrow. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. With that, you are all excused for the evening. We'll see you back here tomorrow at 8:30 a.m. All rise for the jury.
Let me see if I can find that for...
All right, thank you, everyone. We are in recess. We'll see everyone tomorrow morning at 8:30. 8:30 a.m. I trust that the jail will give you a shower, so whether that's tonight or tomorrow morning before you come back to court.
Definitely.
But I will order that.
In the morning. That's dead. 8:30?
8:30.
I'm not getting up there early. This got to be some tonight type thing going on.
That's when we start court every morning, sir.
No, it haven't been. You did some switcheroos.
What? Okay. Okay, so okay, yeah, we're done with that shit. I want crap. I want to actually go to I want to actually go to the Reddit post. Danny sent me a screenshot of it. Is it still up on the subreddit? Oh, it's been shut down. Are you sure? Oh, it's been banned. Guys, it's been banned. Justice for Dale has been banned. I just went to Justice for Daryl subreddit and it's gone. But in the meantime, Mandy did send me the screenshot. Yeah, exactly. Pulled it and the subpoena's going out for the IP address.
Generally, but
I want to go through the rest of the clips from this morning, and then I want to go actually read through this post, which I read it already at least once, and it's
specifically.
I find it a bit sus.
Are you done?
Sir, that's very rude and
No,
disrespectful.
I didn't know if you was finna say something.
I
That's why I'm
paused.
asking, are you done?
What filing
Your Honor,
are
how
you
come
referring
every
to?
time I try, even when I try to err on the side of caution, you find some way to make it to be something that it's not? I didn't know if you was gonna say something else.
I've asked a question, sir, so when I do that, I would hope it would convey to you I'm looking for an answer. So which filing are you referring to?
All my filings, my notice of appearance, my statement of particulars, my bond, the court docket sheet, all of those filings.
The request to display those to the jury is denied. It's not relevant.
How's it not relevant? Not even your
That's my
oath of office?
determination, sir. So I am going to start this.
Not even your oath of office can be shown?
No, that is not relevant to these proceedings, sir.
It is.
It's not relevant in front of the jury.
Why is it not relevant? Can you
Mr. Brooks, you
explain
are
why
not
that's
going
not
to
relevant?
be able to raise those types of issues and present a closing argument based upon my oath of office, whether I'm licensed to practice law in the state of Wisconsin.
I said your oath
whether
of
there's
office.
subject
I didn't
matter
say anything.
jurisdiction, whether you consent to this appearance or not. None of those things help the jury determine the issues in this case, which are related to whether you are guilty or not guilty of the 76 charges that have
The
been
jury
filed
should
in
know
this
that
case.
they should know the truth in their duties, in their rights. They should know that at least.
Mr. Brooks, I'm putting you on notice that if you continue with this insistence upon presenting information that's not properly before the jury as evidence in this case, that I will instruct you during your closing argument to move on and potentially ask the jury, have the jury leave so that I can admonish you. And if you keep insisting on that, sir, that will be in direct violation of the court's direction to
So
you.
they can't even know that I got a shock device on my ankles.
They absolutely do not need to know that.
Why
So it's
not?
not relevant to the determinations of guilt or innocence in this
It's
case.
the truth.
Mr. Brooks, your custodial status is not on trial here.
I will argue that it is.
Your conduct from November 21st of 2021 is
That
what is
hasn't
on
been
trial.
proven.
You may not bring up the way that you've been shackled. It's not relevant, sir.
It's
and if
the
you
truth.
do so, you do it at your peril. But here's the
There
thing:
is
the
no
jury
peril.
is specific.
It's my right,
No,
though.
let me go. Okay.
It's my constitutional
is-
right.
Again, he seems to think that he's going to garner sympathy by virtue of the fact that he's shackled, and not think that it's going to prejudice him in the minds of the jury that he's a criminal who is guilty of the crime.
Just like
There are
under the
certain
First
things
Amendment,
that
which I
you're-
preserved my First Amendment right when I came in this morning, I also preserved my
All right,
Sixth
Mr. Brooks,
Amendment right.
Please stop. You do not have an unfettered First Amendment right. That is very clear based upon
What do you
all
mean
the
by
case law.
unfettered? What do you mean by unfettered?
It
I
means
don't.
it is not absolute. It can be restricted.
So the Constitution of the United States can be constricted.
All right, Mr. Brooks, I'm putting you on notice that if you continue with your insistence on raising issues that are
I'm going to
merely
raise
a
issues that the
distraction,
jury needs
that
to
are-
know,
They're not
regardless,
issues.
because they're under the rights of the United States Constitution, which
Mr.
is the
Brooks,
law
I
of the
direct your
land.
attention to closing instruction 460,
I'm
which will be read
going
the
to
jury
let the
at some
jury
point.
know the truth, their duty and their rights. Under the First Amendment and under the Sixth Amendment, I have the right to inform them of their rights, of the truth, and of their duties. Under the First Amendment and under the Sixth Amendment of the Constitution of these United States. You can't. No state law can override that.
Mr.
Any
Brooks,
law,
do you intend
any
to
law
keep this up when the
repugnant.
jury comes out?
Your Honor.
Because I need to
No, I
have
do
the
not. That's
state-
why I'm addressing this before
I'm not-
they come out. That's why I'm trying to address this before they come out, so it doesn't become an issue once they're in here. But under the First Amendment and under the Sixth Amendment of the Constitution, which are rights that I preserved the moment we stepped in here this morning when this proceedings started, I preserved those rights for the record. And now you're telling me that those rights are not, would you say, unfettered or I don't know what you say. I don't even know what that means. I don't even understand that. But
Of course
any
he
law
doesn't know what it
repugnant
means.
Of the United States.
By the way, thank you, Terry, for joining the membership. And thank you, Robbie, for the $4.99 super chat.
Constitution is null and void.
Mr. Brooks, I'm putting you on notice that you can also forfeit by your conduct the right to present a closing argument. In appropriate circumstances, the right to present a closing argument, no different than the right to testify, may be subject to forfeiture where your conduct is incompatible with the assertion of the right at issue. The goals that this court has attempted to follow throughout this proceeding are multifaceted and multifold. Number one, I do have an obligation and I have done my best to ensure that this is a fair trial. However, a fair trial does not mean a defendant has unfettered rights to state whatever he wants when he wants. This court, not only through the course of the trial, is deemed with the responsibility to control the presentation of evidence so as to ensure fairness and reliability of the criminal trial process. It also includes ensuring that the closing argument
This is during the prosecutor's closing arguments.
67 in detail. Counts 68 through 73, hit and run causing death, in my opinion, are easily summarized as this. He never stopped. Never. Bail jumping, he was out on bail for 2 files in Milwaukee County, facing felony charges there. He was ordered to not commit any further crimes. If you believe he was involved in any of the conduct charging counts 1 through 67, you should find him guilty of bail jumping. Battery, that relates to the split lip and black eye suffered by Erica Peterson. We told the story kind of backwards. We started with the battery for background. First degree intentional homicide. You've seen this in our opening statement. You've heard it from Judge Doro. Did Darrell Brooks cause the death of the victim, a victim? Did he act with intent to kill, meaning either the mental purpose to take the life of another or was aware that his conduct was practically certain to cause the death of another human being? Count 1, Ginny Sorensen. Count 2, Lee Owen. Count 3, Tamara Durand.
Oh, I got.
Count 4, Jane Kulik. Count 5, Bill Hospital. Count 6, Jackson Sparks. Those are the individuals who lost their lives because of the conduct of Darrell Brooks. From there we go to reckless endangering safety. What is that? In this case, it means that through his reckless driving, he endangered the safety of other people. And he did so demonstrating utter disregard for human life. Now, behind me is State's Exhibit 15. It's also on the PowerPoint. If you choose, you may have this chart with you in the deliberation room to help you walk through each of these counts if you find it helpful.
Which it did request.
If you want it, you don't have to have it. But it will be available for you if you ask for it. And it'll take you, as we did in our presentation of the case, right down Main Street and address all the counts that were involved, all the counts that were charged. To prove reckless endangering safety, and I'm just going to go back one slide, nowhere do you see there that we have to prove any degree of injury to anyone.
Yep.
Never once did Judge Doro instruct you that somebody has to be physically injured.
Yep.
Now, Detective Casey told you that was the standard we used in deciding of all these hundreds of thousands of people who is included in these charges.
Arian Rod, thank you for the 5 gifted memberships.
And the decision was made by the prosecution team to include people who were physically injured to be efficient in our prosecution. And so everybody up and down the street, I would argue, had their safety endangered that day. I didn't charge 5,000 counts. We selected 61 counts of people that we can identify by name in Exhibit 15 that were injured by the conduct of Mr. Brooks. Those are the people in green. People in red are the fatalities. And we presented this case to you in much the same fashion that is presented here on Exhibit 15 as to how the injuries occurred going down that street. So we are absolutely held to our burden of proof and the elements for each offense that Judge Doro instructed you on, but we are not required to prove any injury to anyone.
That's a good point, Terry. They may have just used
safety
15 to match the counts with the names on the poster.
Reckless driving. Now, some of the groups, it's pretty easy. They walked in a formation, and you can get a photograph or a diagram, and you can kind of see pretty easily who was located where, right? And you can think back to the videos that you've seen for each of these groups and remember, and you'll see them again, the path of the vehicle as it went through each of these groups. This is South Band, of course. All of these names that are being displayed on the PowerPoint Exhibit 21 are on Exhibit 15 in green for Waukesha South Band. Pretty much the whole left half of the four. Now, Mr. Brooks repeatedly asked witnesses.
Oh, This was earlier today. I love this part of the DA's closing arguments. I love it because she directly counters his sovereign citizen garbage.
Who had just watched their loved ones get struck by this SUV if they happen to catch a license plate. State's Exhibit 150, there's the front license plate. Definitely a little blurry, but definitely you can make it out. State's Exhibit 151, there's the rear plate. State's Exhibit 175, there's Daryl Brooks in his music video with the same car and the same license plate. There's the key to the Ford that was found in Daryl Brooks' pocket. There's no doubt Daryl Brooks is the person responsible for this. Because this man in this picture is the same as this man in this picture wearing this sweatshirt. And again, it's a little hard to see, but you can ask for these exhibits in the jury room if you want. The photograph, you can see this design on the front of the sweatshirt if you look close enough. This is a sweatshirt from the playset that has Daryl Brooks' DNA on it, according to the crime lab. That's him right there. That's Daryl Brooks driving off into the parade. That's Daryl Brooks driving in the parade.
Damn.
That's Daryl Brooks driving in the parade. That is also Daryl Brooks driving in the parade. And so is that. And he kept asking people about the tints on the window. Well, guess what, folks? You don't need to see the tints on the window when the windows are rolled down. And there's clearly one person in that vehicle in every one of these photos. And it's that man. And it's that man. And it's that man. Daryl Edward Brooks Jr., date of birth 2/21/1982, on his identification card issued by the state of Wisconsin. In all capital letters, Daryl Edward Brooks Jr. This was in his pocket when they arrested him. So this entire shenanigans that he's presented to you,
Shenanigans.
Questioning of witnesses about I'm not Daryl Brooks and that's my name and I don't know who that is and I don't consent to being called that name. It's just nothing but a distraction. It's Daryl Brooks. It's the man who drove through the Waukesha Christmas parade and killed people, injured people, endangered the safety of people.
I'm sorry. Your objection, sir?
Your Honor, with all due respect, I would appreciate the quote-unquote language what does she mean by shenanigans and this and that and the third?
Oh.
Sir, your objection's noted. It's overruled.
Grow a pair. Oh my goodness.
Can she tone that back? Because if that was me, if I would have said
Mr.
something
Brooks,
like
your
that, it would have been a
objection
problem.
is noted. It's overruled. These are closing arguments. There's nothing improper. It's noted. It's overruled. She may continue.
I just wanted to be fair.
You'll have an
Your Honor, that's it.
opportunity to respond, sir.
Yeah, can we tone down the shenanigans? Ugh. Yeah, the woe is me. Actually, I do want to go to the very beginning because she does and this will be the last clip before I talk about the Reddit post. The very, very, very beginning of the prosecutor's closing arguments, because she directly addresses the entity known as the state of Wisconsin.
You know, all week or
Offer you may. All right. Attorney Opera, you may start.
Thank you, Judge. Good afternoon, everybody. It's kind of nice to stand here in the middle of the courtroom. You know, all week or the last 3 weeks, they shoved me at the end of the table because I'm the lefty in the group. It's nice to be able to look at you all and say thank you truly thank you. Each and every one of you. I want to express our sincere gratitude from the prosecution team, myself, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Woodchow. There's no one in this courtroom that does not realize the sacrifice.
Wait, hold
Deputy
on.
District Attorney Leslie, your gratitude from the prosecution team, myself, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Woodchow. There's no one in this courtroom that does not realize the sacrifice.
Is Opera the district attorney for the county? If so, that's pretty awesome that she's actually taking on the case.
You've made serving your community in this very important
Okay,
task.
she is the actual full-on DA of the county. Good. That's awesome.
I don't even want to hear from your bosses. Thank you. You've watched these proceedings and you've noticed as we sit at our prosecution table, we don't have a client at our table.
Ah, here
But
it
rest
is.
assured, we do represent someone.
There it
We
is.
represent the people of the state of Wisconsin. It's an entity. I can't bring it to the courtroom. People enact laws. People want to feel safe. People have representatives in Madison or Washington, D.C. that set standards, rules that we all are expected to live by. And when those rules are violated, prosecutors step in and enforce the law. Darrell Brooks does not represent anybody. He does not have a client. Darrell Brooks is the client. Darrell
Damn.
Brooks is the defendant. The state of Wisconsin is the plaintiff. It's really that simple. And it's consistent with any other criminal case you've ever heard about at any other time in any other jurisdiction. It runs the same, no matter what state or federal.
Got him.
I'm going to ask you for your guilty vote at the end of my comments. It's up to you. I can't tell you to do anything, except I'm going to say one thing to you that I wholeheartedly ask you to obey.
Attorney Upper, I'm sorry for the interruption. Your objection, sir?
Mischaracterization of who I am and the way it was said. I feel like it was talking down.
All right, your objection.
Oh, woe is me. Oh, she's talking down. Oh, look, all right. Look out there, alpha males. The female's acting all uppity again. So we can't have any of that apparently.
You must.
All right, I'm done. She nailed it and I appreciate it. But I want to go to the subreddit where that Danny was able to capture for me, and I kind of want to read read some of it. So the title of the subreddit is "I am a member of the jury on this case." I have it on my phone, so so bear with me. I am a member of the jury on this case. Here are my thoughts on the trial and on this subreddit. Subreddit being Justice for Darrell. So to start with, I obviously shouldn't be here. I'm not allowed to look stuff up about this trial or really have any connection with the internet, but nobody actually follows the questioning rules anyway. Hence, I'm obviously posting anonymously. I accidentally wandered into here a few days ago from the r/subreddit drama thread on my main Reddit account. Here's my opinion on the trial. First off, I think it's pretty obvious due to chain of custody that the defendant is in fact Mr. Brooks and he did do it. I think it's kind of odd he references the chain of custody to confirm his identity, but and also that he concedes that he did do it, as in, but do what? Like all the charges, some of them? However, I've had throughout this trial doubts about various aspects of this case. 1. The judge is clearly biased against Mr. Brooks. I got that feeling from when we were in the room, and my eyes have been opened to how she acted towards him when the jury was out of the room. So my big question here is, he references when we were in the room, as in what, in the courtroom, or no? But then he refers to the jury in the third person when the jury was out of the room. If he was a member of the jury, he would say when we were out of the room. So that was one of my, there's obviously some red flags that I had in the beginning, but that was one of the bigger red flags that I noted in this. Why is he referring to the jury in the third person if he's supposed to be a member of the jury? Because it's presumed that this juror is watching live streams of the case in his off time. And so he's watching the YouTube thing. So he's watching what's being discussed when the jury's not in the room. Clearly, so to continue on. There was an edit that it was a prank before the subreddit went down. I'm not surprised. I wouldn't be surprised if this was genuine, that it's somebody trying to sabotage the case, and also that it's a bunch of trolls. It could honestly very well be either or. I don't know. It could very well be both. It wouldn't actually surprise me if a member of Daryl Brooks's support actually came on and tried the role with it, but I don't know. I really don't know. Continuing. Clearly, she is not an impartial judge and has been trying to belittle, demean, bully, and pull procedural tricks on him fairly frequently. I had my doubts already, but the subreddit has shown it to me clearly. But you already said that he did it, whatever that means. Artie, check your Discord. I posted the edit saying it was a prank. Hang on. And in which channel did you post that, Jake? Oh, I see it now. I see it. At the very top of the screenshot, there's an edit here, right below the header, that says, "This was all a prank. I didn't think this would blow up like this. We are sorry." If it really was a prank, you are fucking more. I don't want to use the F word, but sorry. You are a moron, and you deserve to get any kind of legal consequences that may be levied against you. Honestly, I don't even know if I want to bother with the rest of it now. I'm not going to bother with the rest of it. But all right, for the sake of completeness, I'll read the rest of it. For the sake of completeness. So I just went through number 1. I'm going to go through number 2. Mr. Brooks has clearly not been given the chance to plead his case in court. He has been silenced and mocked at almost every turn. While he may be a bit loud or crass at times, I still believe his side deserves to be heard. 3, I do have significant doubts about subject matter jurisdiction. I didn't understand it when discussing court because the defendant was repeatedly silenced, but I do understand now thanks to this sub. And I agree that subject matter jurisdiction is great concern here. That this person, whoever they are, they don't explain it. They don't elaborate further on what their questions are or what their issues are with subject matter jurisdiction. 4. This subreddit is maybe aware of jury nullification, and I am very grateful for that. Okay. Overall, I'm not sure what I will decide. I am not educated in the law, and I have to admit I'm biased against the defendant for the horrible acts he did. But you already admitted that you're saying that the judge is biased against him. However, it is also clear that this trial is a complete kangaroo court. Mr. Brooks has not been allowed to try and prove his innocence. Subject matter jurisdiction to explain the circumstances surrounding the events. I think he has. He just does it very poorly. It's hard to imagine what could justify it, but we just can't know because of this trial. For these reasons, I'm torn between locking him up and throwing away the key or jury nullification. Both have arguments for and against them, and I'm not looking forward to choosing. I'm mostly writing this to help myself process my thoughts, but please let me know what you think. I don't know. Do my clip, please. I really want to know what clip, Kit. If I don't see it, I'm gonna close up shop for the night. I did see the response that Kick left. So while Kit is letting me know what clip he's referring to, I'm going to so somebody asked me what my opinion is of the judge's, what's my grade, or how do I think the judge handled the case? I think I gave a hint yesterday or the day before, that, you know, in a grade scale, I'm kind of torn between giving the judge a B+ or an A-. And the reason why I wanted to give that grade is because I think there were more than one instance where I really felt like the judge needed to rein him in, and she didn't. Obviously out of an abundance of caution, but I feel like she still needed to, you know, lay the hammer down and really bring him in, especially when he was, you know, grossly disrespectful and grossly inappropriate in front of her on the record. Beyond that, I think she was put in a very, very tough situation, and I think throughout she's overall handled it very, very well in balancing the defendant's rights, and in other words, balancing Brooks's rights as the defendant, while also ensuring that the case does not get overturned on appeal, and that there's no chance for a mistrial. So I think that's why I'm giving her, you know, somewhere between a B+ and an A-, because I think she did the best job that she could, notwithstanding those isolated moments where I felt like she needed to be a bit more stern, I guess the best way of saying it. So that's my take. Oh, Danny discovered who the suit guy is. In other words, the guy that sits at the far end of the
Does not.
On.
Before is that.
Oh wait, he's not even shown here. What the hell? Where is he? I have to look at it yesterday. Hold on. Hold on.
Without having
This guy. This guy, apparently, the man of mystery, is the county attorney's detective chief investigator, Ryan Roglin. All right. Mystery solved. What else did I have left? Oh, I hadn't even talked about. I hadn't even talked about the weekend. I mean, the long and short of it, I had fun. I got to see Danny. She got to meet the family. The family loves her. She loves them. It was great hanging out with my family. I hadn't seen them in ages. I hadn't seen my brother in ages. So it was good. I had a great time doing some Halloween events. No, I'm not going to discuss the YouTube matter jurisdiction. But it was great. I'm going to be seeing the family again for Thanksgiving. But yeah, it was a lot of fun. All right. I noticed that Mandy's checking out, so I'm going to call it here. I don't want to leave people hanging. Yeah, tomorrow, obviously I'm going to be at work, so I'm more than likely going to miss the verdict live, which kind of sucks, but it is what it is. I got to take precedent of my day job because that's what, keeps the lights on. But obviously I will probably be checking in on the verdict when it comes through, and I'll probably at least have a live stream afterwards to talk about it with you guys, even if it's not live. So I want to thank you guys again. Thank all of you for your generosity tonight. Thank you all of you for the new memberships. And yeah, you guys have yourselves a good night. Take care, and I'll see you next time. Adios. What? All right, I gotta take care of the kitties. All right, bye guys.